Do it. Get this rolling. Are we live yet? Are we not? I think we are. Ooh. Well, I see myself. Bro, look at this squillium hair I got going on right now. What is this? Genuinely, I'm not like doing anything to make it look like that. It just does that. What is this? The mustache is tough, but what is this? Hello and welcome back to the Quiet Part YouTube channel once again. We are doing another speed read live stream. And as you can tell from the current setup of what you can see on the screen right now, we have a few different things. Taking a look in the top left, we have the Supreme Court of the United States, specifically a Supreme Court opinion document in a case called Chiles versus Salazar, who is the executive director of the Colorado Department of Regulatory Agencies. This is a Supreme Court opinion document in a Supreme Court case here in the United States, specifically concerning the constitutionality of a pseudoscientific traumatizing practice in the US known as conversion therapy, which I think my video description for this has the merriam-webster definition of conversion therapy. I wanted to include it for the sake of, I don't know, just doing the right thing. Let me pull up the video description. So, basic things. What is the premise for today's stream? Today's stream is a speed read stream. These streams are speed runs where I'm also listening to text-to-speech reading a piece of legislation aloud to me. And the joke is that I'm doing what nobody wants to do. No one wants to read legal jargon all day, every day for 10 hours a day because it's hard to read and it's not fun to confront all of the injustice that we live through in the United States today. So the joke is, I don't want to read this document. I do. I like educating myself. I like learning. I like reading Supreme Court cases because these things have meaningful effects on people's real lives here in the United States. And this decision, which was decided like 2 or 3 days ago at this point, will have meaningful effects on people's lives moving forward. Yes, I want to read it, but also I kind of also don't want to. And the joke is, what are we going to do? Well, let's set up a challenge. We're going to be speed running Minecraft. And if I can beat Minecraft, I don't have to finish reading the document today. I can finish it on a later stream and take a break. Otherwise, we have to read the entire document straight through until I either pass out or beat Minecraft. In this case, the document, I believe, is only 60-something pages, which is a long enough time that I might have a chance of winning for once, which I usually don't. Because I'm not that fast. The rules for the speedrun are pretty straightforward. I am allowed to generate as many new worlds as I want because this is a shorter document. If the document were over 500 pages, I would force myself to speedrun the first world that I generate. But I'm allowed to generate new worlds until I get a seed that works well for speedrunning. What is, again, the general topic of this Supreme Court decision? It's about whether or not conversion therapy should be constitutional in the United States. And I have to be totally honest, I actually don't know what the answer. I actually don't know what I haven't researched anything about this. All I have done is what you should do, which is check out the video description right now and click on the link I have to the Supreme Court's official like documents organization webpage so you can read the opinion yourself. And we'll find out as I read it whether or not conversion therapy is still constitutional. I believe it's not. That's just like what I personally remember. I'm pretty sure the Supreme Court ruled, unsurprisingly, seeing as it's completely packed with like insane Christian nationalist conservatives, I believe they ended up ruling that conversion therapy is still legal in the United States. But I'm not totally certain. I won't know until I read it. And yes, I could read a article from a known publisher, but none of that is to the same degree as sitting down and reading these documents yourself. So here's how this is going to go. I'm going to start the speed run at the same time that I start having the document be read aloud at a variable speed by Microsoft Edge's read aloud tool feature. And I'm not going to pay incredible attention to the document, but I will pay enough to at least have skimmed it. And then at the end of the stream, I will go back through it one more time for comprehension. But the joke is I'm both speedrunning while having to listen to horrors within my comprehension, assuming that they decided that the abusive, pseudoscientific, anti-intellectual, anti-professional child abuse schema, which is conversion therapy, if they ruled that it's still constitutional despite being a form of torture, that's going to be messed up. We'll see how it goes. All right, I'll start the document first, and then I will start Minecraft after, and we're going to jump straight in. Okay, let me know in the chat if anything is hard to hear or if I need to adjust volume. I seem to have it at a pretty okay level. Now, I'm going to start it, and then I'm going to start Minecraft. 3, 2, 1, let's go.
Feasible.
New world.
Syllabus. Headnote.
Let's get it.
Released.
Okay.
Is being done in connection with this case.
All right, where are we at? Where are we at?
Is issued. The syllabus constitutes no part of the opinion of the court, but has been prepared by the reporter of decisions
it's not a great
for the
seed.
Convenience of the reader. See United States versus Detroit Timber and Lumber Company, 200 U.S. 321.
This does not look like a great seed.
337. 1. Supreme Court
of the United States.
Syllabus. Chiles v. Salazar.
Okay, Chiles. That might not be the actual pronunciation, but I'm going to say Chiles.
Department of Regulatory.
So Salazar is a director
certiorari to the United
in
States
Colorado.
Court of Appeals for the 10th Circuit. Number 24 to 5.
I live in Colorado, by the way, so that's relevant.
Argued October 7th, 2020.
This was argued on October 7th.
March 31st, 2026.
Some months ago. Decided
Kaylee Chiles
3 days ago.
A master's degree in clinical mental health and a state
counseling
license in Colorado. Ms. Chiles does not begin counseling with any predetermined goals. Instead, she sits down with clients, discusses their goals, and then formulates methods of counseling that will most benefit them, seeking throughout to respect her client's fundamental right of self-determination.
Self-determination.
On matters of sexuality and gender, Ms. Chiles's clients, including young people, often have different goals. Some are content with their sexual orientation and gender identity and want help with social issues or family relationships, while others hope to reduce or eliminate unwanted sexual attractions, change sexual behaviors, or grow in the experience of harmony with their bodies.
Okay.
With all those clients, Ms. Chiles seeks to help them reach their stated objectives. And she employs only
talk therapy.
In 2019,
which respectfully is already not an extraordinarily well-evidenced sub-format of counseling, but whatever.
From engaging in
we used to just call it psychotherapy.
With minors, Colorado Reverend Stat.
Okay, in 2019, Colorado adopted a law prohibiting conversion therapy,
224(1),
which is a reasonable thing.
Defining the term to include any practice or treatment that
attempts to change.
Well,
as long as the counselor wasn't actively trying to change the child's identity for them, it should have been fine. If the child is doing that autonomously, then it should be fine legally, right?
Sexual or romantic attractions toward individuals.
Because technically the child isn't a practitioner, they're a patient seeking their own goals.
202, 3.5a. Yet the law explicitly allows counselors to provide acceptance, support, and understanding.
Okay, so it sounds like the original law was actually rational. That sounds reasonable.
245, 202.
I think we're giving up on this run already. This doesn't look good.
And to assist persons undergoing gender transition. Section 12, 245, 202, 3.5.
It's a nice village.
Ms. Chiles filed suit in federal court. 2 Chiles v. Salazar.
I don't know if I should try this seed or not.
Seeking a preliminary injunction, raising a First Amendment challenge to the law as it applies to her talk therapy.
I don't like it. There's too much water in this spawn.
Chiles had Article 3 standing to pursue her as-applied pre-enforcement challenge.
Okay, of course I know I should technically be focusing on the speedrun, but comprehension is more important to me. I still like knowing. So Kaylee Chiles is a doctor that wants to do gender conversion and is challenging the constitutionality of Colorado's law that made that made conversion therapy illegal.
Challenge. On the merits, however, both courts denied Ms. Chiles's request for a preliminary injunction, reasoning that Colorado's law is best understood as regulating professional conduct and that it regulates speech only incidentally, thus triggering no more than rational basis review under the First Amendment.
Okay, so at first, Colorado was like, no, this isn't going to go.
A circuit conflict over how the First Amendment interacts with laws like Colorado's when those laws are applied to talk therapy.
Okay, so the Supreme Court took over once they decided that.
Conversion therapy, as applied to Ms. Chiles's talk therapy, regulate speech based on viewpoint, and the lower courts erred by failing to apply sufficiently rigorous First Amendment scrutiny.
Okay, so they're saying that the previous courts that didn't take the case for primary injunction is no.
Every individual to decide for himself how best to speak. Riley versus National Federation of Blind of N.C. Inc. 487 U.
How does this work in a medical context? Is a doctor allowed to say non-medical things to a patient and not be liable for it?
Unconstitutional, triggering strict scrutiny that requires.
Oops. So, yeah, I knew this was probably going to go the First Amendment route. The pro-conversion therapy counselor was going to say, "Hey, you're getting in the way of my First Amendment right to talk therapy how I want," which is confusing and interesting because it's not like she's speaking on that topic in her capacity as like an individual person. She's speaking on that in her capacity as my camera messed up already. That took no time at all, huh? It's not like she was speaking in a professional setting. Are you speaking like privately in your own capacity? Or are you're not. Well, if it's a private practice then, right? I'm not really sure how that actually plays out. I don't know. Okay, let me fix this. It looks like my camera has already messed up and we've barely even gotten started, haven't we? Alright, what do I do here? Now I'm fixing my camera, but it's so interesting. I guess the argument is going to be that she is, and my camera is no longer showing up. Great, wonderful, classic. I'm going to unplug my camera then, we'll see how that goes. Camera? What is the issue with my camera right now? Okay, I'm unplugging it and fixing it. So, I think the reasoning is going to be that I'm a private practice counselor. This is my business. And as long as I'm not doing anything illegal, I can talk to the kid about conversion therapy. If I want. Is that the reasoning? Is that the sort of defense that's going on here, I guess? Alright, are we going to give me my camera back or what? Camera's back. Wonderful. Very exciting. All right, let's freaking fix this then. Hello, me. Oh, let me turn this down a little bit. Something else. Oh, too much. Understood. Oh my god, I can't get it. So I'm suspecting legally. We're getting multiple audio now. That's got to be annoying. I'm suspecting legally the argument on the case of Chiles is going to be, I am a private practice counselor and I'm allowed to speak freely as I please. And the Colorado's law against conversion therapy is stepping on my right to speak freely. I wonder, and I don't know, but I wonder, oh, there's my old video. So I guess that's gone now too. Great. Let me fix that. I wonder what the law, what the constitutionality of this is with doctors. Is a doctor allowed to, I think so, because there are doctors who have incorrect beliefs about things like chiropractors. There exist doctors that have objectively, scientifically, empirically wrong opinions on things like chiropractors and, you know, herbal medicine and what do you call that entire scam business? What do you call this? Homeopathy. I believe a doctor can speak to a patient about homeopathy legally, and as long as the patient doesn't get harmed as a direct consequence of the doctor's work, the patient cannot civilly sue the doctor, or at least they won't have a legal basis to civilly sue the doctor for damages or harm. Though I do believe patients can sue doctors. That's a thing. for the outcomes of their work. In this case, as someone who recognizes, someone with a brain who recognizes that conversion therapy is traumatizing, it is like a form of torture. If a counselor were to employ conversion therapy, torturing a child essentially, could a family, before this ruling, could a family civilly sue the counselor for harm to their child? Probably. So, to some degree, I guess restrictions already existed limiting the ability of people to harm others as therapists. I'm sure there are board things and licensing things, and there's going to be agencies that influence that, but there was also the fact that you could civilly sue someone. But I wonder if they can make you sign a contract that says you're not allowed to sue for effects of the counseling. I wonder if counselors are allowed to write that into their stuff. Put the cat away. I don't know. So this is really just a matter of whether or not the Colorado law banning conversion therapy is constitutional and in the way of First Amendment rights to free speech of a private counselor to do as they please with their patients. What if a counselor...
I have a question.
What?
Do you want baked potato?
Sure.
How many?
One.
Just one?
Yep.
Single baked potato?
I wonder if is it legal for a counselor to tell a schizoaffective patient that their demons are real and to listen to them? Can you do that? I'm sure you would lose your license, right? And you would lose your accreditation, and then you could be civilly sued. I'm not sure if you could be criminally sued. But big questions from the very beginning about existing law concerning medical practice and counseling practices. All right, back to the reading.
3 cite as 607 U.S. ____.
I know that this also looks like a crappy spawn.
Syllabus.
It needs to stop putting me in such dense
To
areas.
express acceptance and support for clients exploring their identity or undergoing gender transition, Section 12, 245, 202, 3.5b, but forbids her from saying anything that attempts to change a client's sexual orientation or gender identity.
You can't
including
attempt to
efforts
change it.
Behaviors,
If the
gender
child
expressions,
chooses
or
that, then the
romantic
child
attraction.
does.
Section 12, 245, 202.
I feel like that's an obvious thing that a court could have
3.5a.
navigated.
Her speech does not become conduct,
just because
a
of
government
conduct.
says so, or because it may be described as a
Treatment.
or therapeutic
So we're doing the
modality.
old nuance of...
The First Amendment is no word game, and the exercise of constitutional rights cannot be circumscribed by mere labels. NAACP v. Button.
Minecraft.
371 U.S. 415, 429. The
Accidentally
fact that
quit
the
out of
state's
habit.
viewpoint regulation falls only on licensed healthcare professionals does not change the equation. The First Amendment protects the right of all to speak their minds, and NIFLA expressly rejected the notion that professional speech is...
Okay, we're going to slow it down more. I really forgot that this is at a college writing level sometimes. The First Amendment is no word game. In the exercise of constitutional rights... Let me get OBS pulled back up. Minecraft is back up. Okay, cool. So at least some of these other worlds. Creating yet another world. The First Amendment is no word game, and the exercise of constitutional rights cannot be circumscribed, cannot be gotten around through labels. The fact that the state's viewpoint regulation falls only on licensed healthcare professionals does not change the equation. It's interesting though, but the Constitution has ruled that public educators, for example, have limited free speech protections. Why not doctors and counselors? The First Amendment protects the rights of all to speak their minds. No, it doesn't. It genuinely does not protect teachers as much as normal people. Teachers get less. They are licensed education professionals. NIFLA expressly rejected the notion that professional speech is subject to diminished constitutional protection. Yeah, but again, it's different in schools. History is littered with examples of governments that have sought to manipulate professional speech to increase state power, suppress minorities, and censor unpopular ideas. Okay, interesting.
3 cite as 670.
Okay, well, we're restarting it. It's fine.
____ 2026. Syllabus.
Hey, we got time. We got time. We got to remember that.
To express acceptance and support for clients exploring their
Wow, this is a
identity or
terrible
undergoing
spawn in
gender
one way, but in
transition.
another, it's okay.
Section 12, 245, 202.
This is an evil spawn to put a person in.
B, but forbids her from saying anything that attempts to change a client's sexual orientation or gender identity, including efforts to change behaviors, gender expressions, or romantic attraction. S. Section 12, 245, 202, 3.5a. Her speech does not become conduct just because a government says so or because it may be described as a treatment or therapeutic modality.
I actually think that's pretty strong reasoning.
And
I actually don't disagree.
Exercise of constitutional rights
Obviously,
cannot
like,
be circumscribed by mere
manually
labels.
trying to do conversion therapy has got to be different from
button,
just talking to a kid
371 U.S.
at all.
415, 429.
I feel like the obvious resolution
The
here
fact
based
that
on
the
this...
state's viewpoint regulation falls only...
Okay, commentary on the 3rd page. I think the obvious solution here is that the Colorado law got struck down as unconstitutional. So write a new one where you say explicitly, if you are demonstrably doing conversion therapy, it's illegal because it causes harm. Not if you're speaking freely. Like, just write another version of this law and still make conversion therapy illegal. Just do that.
Only
I think that's common sense.
Healthcare professionals does
But we'll
not
see.
change the equation.
There's going to be a lot of nuance and a lot of debating and a lot
The
of...
First Amendment protects the right of all to speak their minds, and
That's how these always go.
expressly rejected the notion that professional speech is
I also don't
subject
think this
to
is a good enough
diminished
spawn. I
constitutional
don't see any lava
protection.
pools anywhere either, do I?
585 U.S. at 767. History is lit tiered with examples of
Oh, I think
governments
by
that have
page
sought to
like 10, I
manipulate
really have to have
professional
chosen
speech to
a spawn.
increase state power, suppress
I
minorities,
really have to.
and
Oh my
censor
god, it's a
unpopular
biome entirely made of
ideas.
ice. Why do I keep getting ice
At
biomes?
771. Colorado's law does not implicate any recognized exception to the court's usual First Amendment rules. It does not require disclosure of factual, non-controversial information in
Commercial speech.
ID at 768, and as applied to Ms. Chiles, it does not regulate conduct in a
Colorado's law does not implicate any recognized exception to the court's usual First Amendment rules. It does not require disclosure. It does not. And as applied to Ms. Chiles, it does not regulate conduct in a way that only incidentally burns speech. All she does is speak, and speech is all Colorado seeks to regulate. Interesting.
a way that only
What a weird
incidentally
way of
burdened
justifying
as
conversion therapy.
speech ID at 769.
Anytime
All she does is
free speech
speak,
comes up, you
and
have to ask
speech is
yourself,
all Colorado
are the
seeks to
people
regulate.
involved truly speaking to defend free
Colorado's
speech, or are they
argument that
defending
the
their
law
right to do something
regulates
terrible?
speech only
You have to ask yourself that every
incidentally
time it comes to the
fails
topic
because
of free
the
speech.
court's incident to conduct
You know,
doctrine asks
I
whether the law restricts speech only
I
because
have to
it is
admit, I'm starting to feel like this
related to
counselor
unlawful
genuinely cares about
conduct,
free speech, but we'll
or
see.
whether the law restricts expressive conduct only for reasons unrelated to its content. Colorado's law does neither. Ms. Chiles's speech does not bear a close causal connection to any separately unlawful conduct, and the state's law trains directly on the content of her speech, permitting some viewpoints but not others.
Okay, but so then this is an application of the First Amendment. Are we at the point where... Because I would consider conversion therapy by virtue a form of hate speech, because it literally seeks to take an identity of a person and make that identity not exist. That's like erasure. That's like, I consider that a form of violence, right? I might consider it a form of violence, but I bet the average American probably actually doesn't. But one must know that hate speech is illegal in the United States because it compels people to violence. Calling for a lynching is allowed to be censored in the United States because it compels people to violence. Is philosophically trying to convert a person out of their gender identity a form of violence? I mean, if the data is anything to go off of, it is only harmful. Yes. There's like 1% of cases where it's okay. But 99% of the time, as applied, it is a practice that pretty much only causes harm. So, permitting some viewpoints, but not others. Yeah, like but the thing is, in America, we live in a modern world where like the viewpoint of lynching people is not allowed. It's not permitted. Hate speech is illegal. The Constitution has ruled on that. But it's allowed when it's gender conversion or conversion therapy with an outcome planned and the data shows that it causes harm. That's allowed? This could have gotten into the conversation of, if we're going to say that compelling people to lynch black people is not allowable, then what about calling for the non-existence of queer people?
pp.
I don't know.
11 to 17.
Complicated.
C. Colorado cannot establish that applying its law to Ms. Chiles falls within a long tradition of permissible content regulation. Colorado's arguments proceed at far too high a level of generality, asking the court to recognize a broad, First Amendment free zone for speech the state considers
Substandard care. I feel like that's somewhat rational.
United States v.
A doctor...
Stevens,
free speech shouldn't matter if a doctor with a license and in a position of trust is telling people to use homeopathy and then they die from it.
Precedents foreclose aggregating
that doctor should be held accountable.
Regulations to sustain some new and broader category of lesser protected speech. Even taking each of the traditions Colorado invokes on its own. For Chiles v. Salazar. Syllabus. Terms,
a bunch of dogs.
None supports the state's position. Colorado's suggestion that the statute represents a traditional law licensing of medicine fails because the state has not presented persuasive evidence of a historic tradition. The first state, Counselor Licensure Bill, was adopted only in 1976.
Dude, that was 50 years ago.
Licensing laws have traditionally addressed qualifications, not dictated a professional's.
If you're using conversion therapy, you're not qualified.
Colorado's it's
pretty straightforward reasoning.
Laws fails because such laws regulate speech only incident to separate physical conduct and usually require disclosure of only factual and uncontroversial information, whereas Colorado's law as applied to Ms. Chiles seeks to silence a viewpoint she wishes to express.
But again, lynching is a viewpoint that is legally allowed to be regulated in the United States. There are instances of viewpoints not being allowable to express.
Exact ing proof of injury caused by breach of duty, provid, ing, breathing room for protected speech, Illinois ex rel. Madigan versus telemarketing.
Yeah, I gotta read through that. That was pretty huge. Finally, Colorado's invocation of traditional tort claims for malpractice fails because malpractice actions require exacting proof of injury caused by breach of duty. Oh, what? And because it's mental health, it's harder to tell apart? And you guys are all 80-year-olds in the Supreme Court?
US 620, whereas Colorado's law threatens fines, probation, and loss of license simply for expressing a particular view.
If you are expressing support for lynching as a counselor, you should lose your license, probation, or possibly be fined. I support that. Similarly, I support if you are a counselor and you are supporting conversion therapy and implementing it, just like a doctor implementing homeopathy. If you're a snake oil salesman, you're a snake oil salesman. And if the snake oil is poisonous, that's even worse. And conversion therapy is well evidenced and known as being toxic and unhealthy. It is like a form of torture. But this is not simply expressing a particular view. It's like a form of torture when actually implemented. Is the issue that the Colorado law didn't carve out the obviousness of saying if you do it and apply it in such a way as that it causes notable mental distress, now it is illegal. It's now conduct. It's not just speech. And does not allow clients. Colorado's law threatens fines, probation, and loss of license simply for expressing a particular view, and does not allow clients to consent to practices that depart from the prevailing standard of care. I can get behind our crazy Supreme Court. That's fair reasoning. I'm not going to deny that. That's fair reasoning.
Consent to practices
I'm not going to fight that at all. That is fair.
Prevailing standard of care. pp. 18 to 22. D.
This one might be viable.
The First Amendment stands as a bulwark against any effort to prescribe an orthodox
to be anti-dogmatic
views,
and be
reflecting
anti-orthodoxy.
a belief that each American enjoys an inalienable right to speak his mind and a faith in the free marketplace of ideas as the best means for finding truth. Laws like Colorado's, which suppress speech based on viewpoint, represent an egregious assault on both.
Okay, yep, I think we're probably gonna run with this spawn now. This is viable.
116F.
Okay, let's get it. I think we have a chance. We really do.
Reversed and remanded. Gorsuch, J., delivered the opinion of the court, in which Roberts, C. J., and Thomas, Alito,
Sotomayor, Marquette. That's almost everyone.
Kavanaugh, and Barrett, J.J., joined. Kagan, J., filed a concurring opinion, in
Sotomayor
which
joined.
Sotomayor, J., joined.
One dissenting.
Jackson, J., filed a dissenting opinion.
Okay, let's do the math then. So 1, 2, 3, 4, 5, 6, 7, 8. 8-1 ruling? 8-1, only Jackson J filed a dissenting opinion? Is that 8-1? Do we have 9? How many SCOs people we got? Nine, right? I'm not crazy. 1 Chief Justice and 1 8 Associate Justices. Yes. We have 9 right now. So this was 8-1. Double check. Roberts is 1 dude. Thomas is 1 dude. 2, 3, 4, 5, 6, 7, 8. 8-1. It's an 8-1 ruling. So, yeah, I don't know. I am going back and forth on this. I think we should live in a world where conversion therapy is considered a form of violence, because it is, and the data shows that, and we live in a world based on facts and data. But also, I understand protecting free speech here. Interesting, definitely interesting. It's an 8-1.
As 607U.
Oh no, it went back. Do not do this. Oh wait, is it starting there? Oh yeah, huh. Now it's technically starting the actual opinion and not just the introduction. Okay, all right, read aloud. Back to it. I think we're running with this world. This is a good world.
Petitioner v. Patty Salazar, in her official capacity as Executive Director
Chiles
of the
versus
Colorado
Salazar.
Department of Regulatory Agencies, ETAL. On writ of certiorari to the United States Court of Appeals for the 10th Circuit. March 31, 2026.
Okay.
Justice Gorsuch delivered the opinion of the court. Kaylee Chiles is a mental health counselor in Colorado. In this case, we consider her First Amendment challenge to a state law regulating what she may say when speaking with her clients. IA. According to Ms. Chiles's verified complaint, She holds a master's degree in clinical mental health and a state counseling license. App to pet for Cert 212A app.
Cool. Cole already. Good.
Clients seek her help on a wide variety of mental health issues, including trauma, addiction, eating disorders, gender dysphoria, and sexuality. ID at 206A, 207A, 215A.
Wow, a bunch of Cole from the very
Ms.
beginning.
Chiles does not begin counseling on any topic with any predetermined goals. ID at 207A. Nor does she seek to impose her values or beliefs on clients.
You can say that, but what does it mean beyond that,
at
though?
212A. Instead, she sits down and talks to them about their goals. ID at 207A. See also ID at 213A.
Let's get it. Okay.
Only after clients have identified their own aspirations does Ms. Chiles begin. To Chiles
It's on
v.
sand. It says I'm
Salazar.
near sand right now.
Opinion of the court.
Okay, we're already moving.
Formulate, ing, methods of counseling that will most benefit them.
Oh, I'm already super
ID
near a
at
freaking chest.
207A.
I have now passed it. That's
In
not
any
good.
counseling that follows, as well, Ms. Chiles seeks to
Oh, we're
respect
already
her
super
client's
close. What?
fundamental
This is a
right
good
of
spawn.
self-determination. IBID. On matters of sexuality and gender, Ms. Chiles's clients, including minors, come to her with different goals in mind.
Okay, it's like here-ish.
Some are content with their sexual orientation and gender identity and seek assistance only with social issues, family relationships, and the like.
Is it like
ID
rereading a lot of
at
the earlier part, or am I going
207A,
crazy?
213A, 214A. In cases like those, Ms. Chiles does not try to persuade her clients to change their attractions, behavior, or identity, but aims instead to help them address their stated goals. ID at 214A. See also ID at 207A. Other clients, however, come to her hoping to reduce or eliminate unwanted sexual attractions, change sexual behaviors, or grow in the experience of harmony with their bod, IES. IBID. And in these cases, too, Ms. Chiles seeks to help her clients reach their own stated objectives. IBID.
And that may
In
involve
doing so,
denying
she does not
their
prescribe
sexual
any medicines,
dispositions.
perform any physical
True, she definitely
treatments,
doesn't.
or
She's not a
engage in
psychiatrist. She's
any
just a counselor.
coercive or aversive practices. ID at 205A, 207A. All Ms. Chiles offers is talk therapy. IBID. B. In
Well, where the hell is this treasure
2019,
chest? Oh no, that's not
Colorado
good. I did not want
adopted a
that.
law prohibiting licensed counselors from engaging in conversion therapy with minors.
Okay, am I crazy, or did they like meaningfully restart their intro again? No, right. So before it was just kind of the intro and the overall opinions. Now we're restarting with the
Colorado Reverend Stat Section
Understood.
12, 245, 224.
just
1
where the hell.
v. 2025. The state
Where the hell's
reports
this
that it
treasure chest?
adopted the law in response to a ing
was it
mental
over
health
here?
crisis among Colorado teenagers and mounting evidence that conversion therapy is associated with increased depression, anxiety,
Yes,
suicidal
it is bad
thoughts,
for kids.
and suicide
Who knew?
attempts.
It's been bad for kids for like
Brief
ever.
for respondents 11 to 12. Any call Oridan who thinks a licensed counselor is engaging in conversion therapy may file a complaint with a regulatory
Oh, so it's not even
board.
automatically illegal. This doesn't sound like a
See
terrible law
Section
then.
12,
I'm so confused.
245, 226, 1A, 2.
Okay. All right. We're getting rid of all the sand
A
then.
complaint, in turn, triggers a disciplinary review process that can yield a fine. Cite as 607 U.S. _____ 2026. Opinion of the court. 3. Probation, or the loss of a license. See Section 12, 245, 225, Brief for Respondents 9. The term conversion therapy may evoke physical techniques such as electric shock, K, therapy aimed at an individual's sexual orientation or gender identity. ID, at 4. But Colorado's ban on conversion therapy reaches further, forbidding any practice or treatment that attempts to change an individual's sexual orientation.
Okay, game. What the genuinely? What the hell? Where is
Section 12, 245?
Where's the treasure chest?
3.5a. Emphasis added. The law forbids as well any effort to change behaviors or gender expressions or to eliminate or reduce sexual or aromantic attraction or feelings toward individuals of the same sex. Ibid. At the same time, the law explicitly allows counselors to engage in practices that provide acceptance, support, and understanding for the facilitation of an individual's identity exploration and development.
Yeah, exploration,
Section
not 12, to a determined outcome.
245, 202, 3.5b.
Okay, all right.
Likewise,
these are okay items for now.
Counselors to
I would have liked better, honestly.
Provide.
All right, we are now looking for. We have the material to make buckets.
Tie-in.
Now we kind of want to find a
12, 245,
lava pool somewhere.
3.5b. 2.
A village would be nice too.
After Colorado adopted its new law, Ms. Chiles filed suit in federal court and sought a preliminary injunction prohibiting the state from
so injunctions are for prohibiting the enforcement of laws.
That the statute has many valid applications.
Okay. Sounds like she recognized.
Ms. Chiles did not take issue with Colorado's effort to ban what she herself calls
just don't do it in a way that regulates speech. This might be a rational little Supreme Court decision.
Brief for Petitioner 10.
This seems reasonable.
Ms.
Is there anything I'm missing?
Chiles objected to Colorado's law only as it applies to her talk therapy that involves no physical interventions or medications, only the spoken word. Motion
let's make sure.
Preliminary injunction in number 22 CV 2287.
Where do
Colorado, ECF document.
Increase
29, pages 2 to 3.
Infinite frame
15.
rate. Wait, what do I make sure? Oh yeah, it's already rendering as far as it can.
With respect to gender identity, she
I see lava over there.
Law permits her to speak in ways that encourage
I see light under the water over there.
Gender transition,
but I mostly just see lava over there.
Prohibits her from speaking in.
Let's see if I can make this. Oh no, I didn't.
Ways
no.
that help a client realign his.
Where did I just jump from? Maybe
sex.
Directly next to the
For child
giant thing I just
Salazar.
made. Hey, why is there 5 million enemies? What's going on? Is there like a thing going on? It's causing 5 million enemies?
11.
What is going on?
CECF
Is the game like pissed that I built upwards?
To 20. With respect to sexual orientation,
Game, what the hell?
Chiles continued. Colorado's
I only
law
just barely
similarly
remember what
allows
direction I should be heading in right now.
client's sexual orientation, but prohibits
I think it's
her
this
from
direction.
speaking
Oh my
in
god,
any
game.
way
What the
that
hell?
helps a client change his sexual attractions or behaviors.
I think I got most of
Brief
my
for
items.
Petitioner 11. See ECF document 29.
It's over there.
17
I see
to
the
20.
lava over there. That's what matters.
Even though Colorado's law surely has other constitutional applications, she insisted, these constraints strip her of her First Amendment right to speak
for
freely
clients.
with her clients in ways
Is
she
this kind of like a
believes might help them
performative Supreme
meet
Court case
their
where it's
own
just like, hey, I'm
goals.
pro free speech and I want to get a
Brief
recognition for that?
Petitioner 12. See
That's all right.
ECF document 29 at 2
And I
to
guess
3.
it's a way of telling the Colorado lawmakers, hey, if you're going to write this, you need to write it better and truly
Both
protect
the
kids
district
in a way that
court
doesn't
and the
get in the way
10th
of
Circuit
free
determined
speech.
That Ms. Chiles had Article 3 standing to pursue her as applied pre-enforcement challenge.
I'm kind of seeing it, actually. Yes, we should ban conversion therapy.
1178,
But you should write it in such a way that it can't be challenged.
2024. Civ. Action number 1
Like, duh.
22 CV 2287.
Oh, is it a
D.
pool?
Colorado,
That's one thing of
December
lava.
19th, 2022.
Not good.
App 139A.
Okay.
In support of their conclusion, both courts read Colorado's law as prohibiting licensed counselors like Ms.
Oh, I do have a
Chiles
single
from
diamond. That makes a
engaging in
difference,
any
right?
attempt, including through speech, to help a
Oh my god, I'm out of wood again. I'm already out of wood.
gender identity or sexual orientation. 116F 4th at 1197. App 141A 142A. Both courts understood this prohibition as extending to any attempt,
We are going to build
including through
some
speech,
buckets.
to change a client's behaviors or gender expressions or to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex.
Okay.
Section 12.
Bucket of lava, a bucket of water. But that's not enough. I need way more than this.
3.5.
I don't know how to make like a lava generator. And in fact, I don't think you can make a lava generator the way you can make a water generator in this game.
App 141A.
See, like, I see more lava up there,
142A.
but
As both courts saw it, too, Ms. Chiles had previously spoken in ways the law now forbids, and she would continue speaking the same way but for Colorado's.
I never
New
made a
law.
pickaxe? Oh, I just never picked up my pickaxe, did I?
116F
God dang it.
at 1196 to 1198.
I don't have enough iron now.
App 141A, 142A.
But I'm pretty behind in the game because of
Finally,
that. That's not good.
Both courts concluded that Ms. Chiles had alleged a credible threat that the state would enforce its law against her if she continued
Okay, shit, so I need to make a
speaking as she had in the
stupid
past
stone
and
pickaxe
wished
for
to
now.
do in the future. Indeed, both courts cite as 607 U.S.
Oh my god, I've lost my iron
2026.
pickaxe. That's so not good for this run.
Opinion of the court.
Okay, hey, I unfortunately do want to comprehend what I just read. I'm sorry. In support of their conclusion, both courts read Colorado's laws prohibiting licensed counselors like Ms. Chiles from engaging in any attempt, including through speech, to help a minor challenge his gender identity or sexual orientation. Both courts appear. Saw 2. Ms. Chiles had previously spoken in ways the law now forbids. She has practiced this kind of intently. And she would continue speaking the same way, but for Colorado's new law. Both courts conclude that Ms. Chiles had alleged a credible threat that the state would enforce its law against her if she continued speaking as she had in the past and wished to do in the future. Indeed, both courts observed. Okay.
5. Observed, Colorado authorities had refused to disavow bringing enforcement actions against her. 116F 4th at 1198 to 1199. App 142A 144A.
Okay,
Under
we're
these
honestly not making good pace in the
courts
speedrun
held
currently.
Ms. Chiles
But I mean, I'm doing better than I would in a lot of others.
faced an ongoing injury resulting from the statutes. Chilling
And the fact that
on her
a chilling
speech.
effect. Yeah. Chilling effect is the phrase they always use.
116F 4th at 1195, internal. Quotation marks omitted, see app 140A, 141A. Satisfied. As well
God,
that
that's so
Ms.
far away.
Chiles's injury was traceable to Colorado's.
Oh, that's so far away, and
Law
I don't have
and
blocks.
redressable by an as-applied constitutional
Here,
rule.
straight up sand. Cool.
In her favor, both courts held that she possessed Article 3.
Oh, that's a lot of lava.
Suit. 116
But it can only be from,
4th
like, one block at a time, usually.
1199, App 145A. N5. In coming to this
Ooh,
conclusion,
interesting.
the lower courts joined. Others that have found standing in similar cases involving similar
This is honestly
statutes.
starting to look like a pretty
C,
middle of the
e.g.,
road
Tingley
decision.
versus
Like it's,
Ferguson, 47
it sounds like Colorado did not write this law to be constitutional enough to be held up.
1066, CA 9 2022, Catholic Charities of Jackson.
Uh-oh.
Noe and Hillsdale.
Hey, are these no, wait, these are
CTYS.
multiple,
5, Whitmer, 162.
Okay then, cool.
686,
Multiple buckets of lava. I mean,
691.
a lava pool would be a lot better, but
CA 6 2025.
I want to get to the top of this by the time the sun rises next in the game.
Asterisk we, too, agree that Ms. Chiles has standing.
Wow, there's lots of lava
Before
pools
us,
around here.
Colorado only half-heartedly contests the point, suggesting Ms. Chiles cannot establish a present intention to speak in a way the law forbids.
Thank you. Go away.
Brief for respondents 23, N 18. But the state's argument is
Leave me
based
alone.
not on some new insight about Ms. Chiles's state of mind, only a new and narrowed construct ion of the statute that the state advances for the first time in this court. ID, at 18 to 19. Colorado's late-breaking construction of its law, however, would render much of the law's language superfluous. Reply brief 2 to 6, People v. Rodriguez Morelos, 562 p.
In the meantime, I'm organizing my gear. Using this lava pool, honestly. Oh, okay, we might have plenty of iron
presumption against surplusage when
to, at the very least, make more buckets.
The state's new interpretation also seemingly stands at odds with how the state itself
It'd be really nice if I could run into an abandoned portal somewhere. But I'd have to start covering a lot more ground and get it to spawn one.
Motion to dismiss complaint in number 22, CV 2287,
Okay, I'm gonna
D. Colorado,
throw the crap away that I don't need.
52. Page 5 and 3.
No, that's useful.
Separately, Colorado
I don't need to
suggests
table
that
this
Ms.
exact one.
Chiles
I don't really think
has
the
not
emeralds are going to be
shown
useful either, but whatever.
a credible threat.
I'd
that
like
the
to run into a
state
village,
will
so I guess they're worth
enforce
keeping
its
for
law
now.
Against her. Brief for respondents 23, N 18. But Colorado has fought this suit through 3 courts over 3 years and, at argument here, expressly declined to disavow enforcement against Ms. Chiles. TR
More buckets.
of oral ARG 80 to 81.
More exposed iron.
As the lower courts held, no more is required under this court's
I
precedents.
need to make an iron axe before I forget.
116F 4th at 1199. App 145.
Oh, so much exposed iron up here. This is huge.
Anthony List versus Driehaus. 573 U.S. 149. 159.
I forgot how like complicated it is to play a game and listen to this document at the same time and comprehend it.
Salazar.
It's hard.
Opinion of the court. Turning to the merits, both the District Court and the 10th Circuit denied Ms. Chiles's request for a preliminary injunction. The courts recognize that Ms. Chiles provides only talk therapy. 116
Again, like, can a counselor
at 11
like encourage a schizoaffective person to like listen to their demons?
And they acknowledge that Colorado's
And
law
like it would be
regulates the
unconstitutional to
verbal
violate
language
to tell them to
she
not
may use.
listen to their demons? Or could that be wrong?
116F 4th at 1208 C Act.
Could we constitutionally make it illegal to do that?
152A, but the court
To tell them to listen to their demons and go commit crazy acts.
Is to delineate which treatments
I mean, you can't compel, I'm certain you couldn't compel a person to violence, but compelling a person to do something that is not founded in data that will bring about material harm,
116F 4th at 1208
I wonder if you could constitutionally, with the current Supreme Court, could you successfully get that?
Accordingly, the courts reasoned that Colorado's law is best understood as regulating professional conduct. 116F 4th at 12.
Okay, we're getting so much iron. We have so much gear already. Like, I think we're stuck with this world for sure.
151A, 155A. At most, they continued, Colorado's law regulates speech only incidentally to professional conduct. 116F 4th at 1204, C App 155A. As a result, the courts conclude, Colorado's law triggers no more than rational basis. Review under the First Amendment.
There's so much material right now.
Show merely that its law is rationally related to a legitimate governmental interest.
Protecting people and kids is a governmental interest. That's been proven.
At 1215, App 156A. Because the state satisfied that standard, the courts held that Ms. Chiles was not entitled.
God dang it, I keep finding more iron, and it would be nice to have full iron gear.
116F 4th.
Dang it.
1220 to
Be nice to just have freaking
157A. At the 10th Circuit,
oh, an
Judge
abandoned
Hartz
portal.
dissented.
We're in it, boys. We're in it. We're in it. We're doing it.
Several fundamental errors.
Let's get it. All right, we're preparing for that portal end. That's what we're doing right now.
1227.
So yes, more iron. Build towards full iron armor.
Other applications, he observed, with respect to
I think you need 25 pieces to get full iron armor. Pretty sure, something like that.
What she may and may not say.
I'll need to get flint at some point, so I can make a flint and steel, so I can start the portal.
And under this court's precedence,
No way, we're so locked in. This is huge. And there's a village next to it. Oh, I think I see a lava pool over there. We're so set. We're running. We are running. Let's get more iron, so I can build multiple sets of iron armor.
Nor, Judge Hartz continued, does the fact that Ms. Chiles happens to hold a professional license change the equation. ID, at 1229 to 1230. To the contrary, he said, the majority's effort to recast Ms. Chiles's speech as professional conduct amounted to little more than a labeling game.
Okay.
ID at 1231, internal
I see more iron up there.
omitted.
I'm not sure it's worth getting, but I'll go for it.
Cite as 607 U.S. ____ 2026.
Oh, that iron is actually very far away. That's not worth it. I'm not doing it.
Opinion of the court.
Just gonna take what we got, build armor.
7. After the 10th Circuit ruled, Ms. Chiles sought certiorari. In doing so, she argued that the 10th
we're getting it.
Circuit's Deci Shao
We're thoroughly getting it.
worsened a circuit conflict over how the First Amendment interacts with laws like
The
Colorado's.
main thing that ends up limiting me every time I play
Cert 16,
is how long I have to search for a fortress in the Nether.
4th
I need
at
to really focus in on just
1221,
getting into the Nether right now.
47F 4th at
These chickens would be useful.
1077,
It'd be nice if I could get an egg
Catholic
and start a
Charities
farm.
of Jackson, 162F 4th at
No? Okay.
696.
Well, I got food out of it.
versus Boca Raton.
Okay, this way first.
981F, 3D 854, 868 to 870, CA 11 2020. King versus Governor of New Jersey, 767F, 3D 216, 229, CA.
I'm gonna need more food soon. I'm not seeing a lot of stuff to kill.
National Institute of Family and Life Advocates versus Becerra. 500.
Oh, I see a sheep. Huge. And then there's a village next door, so I can get a bed, build a basic house or something,
767
and go from there.
769. 2018.
Perish.
Nifla. Tingley versus
Perish sheep.
Ferguson. 57.
Oh my god, and there's a giant realm, right? Like a giant hole for me to go through.
1085. CA.
Oh god, now I'm gonna have 10 different types of food though. Wait, was that a dog and not a pig? Am I an idiot?
Hearing and bank.
Alright, back to work.
The case. 604 U.S. 1193, 2024. 2.
Okay, building a house inside of this wall.
The question before us is a narrow one. Ms. Chiles does not question that Colorado's law banning conversion therapy has some constitutionally sound applications. See brief for petitioner 53. She does not take issue with the state's effort to prohibit what she herself calls long abandoned, aversive, physical interventions. ID.
But it's the
10.
speech that she's trying to
Instead,
justify.
Ms. Chiles stresses that she
Oh,
provides
Jesus.
only
Oh,
talk
okay.
therapy, employ ing no physical techniques or medications. Yet, she argues, Colorado's law still applies to her, prescribing what she may say in voluntary counseling conversations with her CLINs.
Oh, no, that's not what I need.
ID at
Dig it.
50. And because that application
Okay,
of the
cool.
law strikes at the heart of the First Amendment's
Nope, that's
protections
not what I
for
wanted.
free speech,
Do not do
she
this.
contends, it warrants considerably more searching scrutiny than the rational basis review the Tenth Circuit applied in this case or the intermediate scrutiny review some other lower courts have employed in cases like
Do this so I can remember my spot.
hers. ID.
Okay,
at
definitely want a
38,
chest real quick.
CEG King 767F 3D at 237.
Furnace.
We agree.
Well, I'm jumping the gun a little bit because I have not built
To explain
something
why,
I pretty
we
much need
begin
to.
by outlining the
I haven't built the
relevant
portal.
First
I need to be
Amendment
building the portal right
principles that
now.
govern us before
Oh no,
discussing
but I
how
need
they
food too.
apply here. 8 Chiles v.
Okay,
Salazar.
what am I doing right now?
Opinion
buckets.
of the court.
Some dirt to help me
A.
build stuff. I have 3
First
wool and
Amendment
3 planks, so
envisions
let's
the
go ahead and build a
United States
spawn.
as a rich and complex place where all enjoy the freedom to think as you will.
Okay,
and to
respawn
speak
point
as
set.
you think.
And I need
303
food now.
Creative
Let's
LLC v.
start that.
Lenny's 600 U.S. 570.
Start the food.
584. 600.
I don't have any more food that I can eat on me yet, so
Quoting Boy Scouts of America versus Dale. 530 U.S.
okay, let's take stock.
660 to 661. 2000.
I should have enough. I also hear
Often,
live lava somewhere.
Speech may prove illuminating and inspiring.
Oh my god, an entire... Oh my god, we're so set.
It can be misguided.
We're so set.
offensive,
This is
Or
huge.
cause incalculable grief. Snyder versus Phelps. 562 U.S.
Okay, let's eat. And then let's just try to not screw this up, as hard as it may be. And is, indeed.
But either way, the First Amendment protects the inalienable right of
Okay,
every
and I don't
individual
need
to
multiple
decide
buckets. The
for
ones I have are
himself
fine. So
how
let's
best
just
to
go
speak.
for it.
Riley versus
first things
National
first.
Federation of Blind of N.C. Inc. for 87 U.
Right, I can't use these screwed up ones.
791.
I would have to build replacements.
In this
So I'm just going to let this iron
no
pickaxe go
official,
through it, even though
high
it'll
or petty,
just break it.
may command our tongues or silence our voices. West Virginia BD of Ed V. Barnett,
Dang.
319 U.S. 624, 642,
Oh my god. I'm going to break this entire pickaxe just trying to do this.
Consistent with the First Amendment's jealous protections for the individual's right to think and speak freely. This court has long held that laws regulating speech-based
Okay, let's do this
on
correctly.
its subject
So,
matter or communicative
so I need
content
to
are presumptively unconstitutional.
one of these, one of these.
Reed
Okay,
versus
yes, yes,
Town of
yes.
Gilbert,
Yes.
576
Yes, indeed.
U.S.
Okay, get rid of this one too.
155,
I should really check this chest. What if there's a diamond in it? Nope, there's not.
2015. As a
Flint and
general
steel, that's
rule,
huge. That helps. All right, let's get rid of this.
content-based restrictions trigger strict
So they're
scrutiny,
arguing
a demanding
that
standard
because
requires the
it
government
just
to prove
targets
its
speech in a
restriction on
specific
speech
perspective of
is
speech,
narrowly tailored to
the
serve
law is
compelling
unconstitutional.
state
I
interests.
gotta.
Ibid.
I think I'm agreeing with the justices
Under
here.
that test,
Do I still
it
think we
is
should ban
rare
conversion
that a
therapy? 100%.
regulation will ever
100%.
be permissible. Brown versus Entertainment Merchants Association. 564
Oh my god, it takes so long to break one of these with freaking iron pickaxe.
799, 2011. Quote ING United States versus Playboy Entertainment Group Incorporated. 529 U.S. 803, 818.
Okay.
2000.
One there, one there.
We have
Huge.
recognized
We're getting
as
it. We're like
well
absolutely getting it.
even greater dangers associated with regulations that discriminate based on the speaker's
Alright, no, let me
point
make sure I
of
don't
view.
screw this up because I've screwed it up so many
When
times
the
before. A
government
3x3
seeks
should
not
work. It
just
needs to just be at
restrict
least
speech
2
based
wide
on
and
its
3 high.
subject matter,
So right now it's fine.
but also seeks to dictate what particular opinion or perspective individuals may express on that subject.
I mean, I could just make it
The
taller. Is there any
violation
reason
of
not to? I don't think so.
Cite as
Just go tall then. I don't have an issue with that.
S ____ 2026. Opinion of the court. 9. First Amendment is all the more blatant. Rosenberger v. Rector
Oh my god, there's a witch
visitors
somewhere.
of University of
You're kidding me.
Virginia.
Leave me alone, lady.
515
Leave me alone.
U.S.
Leave me alone.
819, 829, 1995.
Did you just hit yourself with your own
Viewpoint
thingy?
discrimination,
You dumb?
as we have put it, represents an egregious form of
Bro,
content regulation.
the witch is not very
and
smart.
governments in this country must nearly always
I'm still hit though with
abstain
slowness,
from
it looks like.
Ibid.
Did you really
See
just
also
kill
INQ
yourself, witch? Are
versus
you an idiot?
Brunetti. 588 U.S.
No, she's still there.
388,
Oh my god, no, please
393,
stop. All of this is bad.
2019,
Leave me alone.
describing the bedrock First Amendment principle that the government cannot discriminate based on viewpoint. Internal quotation marks omitted. Good News Club v. Milford Central School. 533 U.S. 98. 112 to 100.
Let's go out there and kill that witch.
2001.
Oh yeah, she just tried to open the door.
Barnett, 319
No,
U.S.
not the door.
At 642.
You're making me waste my food, witch, and I'm not
Of
happy about it.
course, with almost any rule comes exceptions. And this court has recognized a few historic and traditional categories of expression long familiar to the bar, where content-based restrictions on speech will not automatically trigger
Okay,
strict
so are they
scrutiny.
acknowledging
Categories that include fraud,
defamation, and fighting
and
words, things that
fighting
incite
words.
direct violence? And they're gonna
United
say
States
that
versus
even though
Alvarez,
conversion therapy
567,
causes material harm to children, it
US
can't count as fighting words.
709, 717, 2012.
Let's get it. Where's this witch?
Plurality opinion.
No more having the high
Alterations
ground, you
in
jerk.
internal
Nice try, idiot.
quotation marks
I'm about to
omitted.
come down on you like crazy.
But, as we have taken pains to emphasize, these exceptional categories are few and narrowly
Jerk.
drawn, and all share a long and well
Oh no, I'm not gonna make it, am I?
historical pedigree. Ibid.
Oh, what?
C. Nifla.
It couldn't kill me all the way? Just most of the way?
S at 700.
Why did it stop at a half heart?
Indeed, even within these categories,
Okay,
we
cool.
have
That works out.
sometimes
Oh,
still
it can
applied
only
strict
take me down to a half heart,
scrutiny.
maybe.
Governments have sought to regulate
Is that it?
speech based on viewpoint.
Okay, sure. I need to get more food. I need to go get hay from that town. Oh, we're so close to being done with this stupid
505 U.S. 377, 392, 395 to 396, 1992, addressing an ordinance that barred certain fighting words based on viewpoint. From these general principles, other more specific ones follow. So, for example, a law regulating the content of speech cannot avoid searching First Amendment review just because it mostly regulates non-expressive conduct. Take a classic illustration, Cohen versus California, 403 U.S. 15, 1971. There, the state of California charged Paul Cohen with maliciously and willfully disturb the peace. ID. At 16,
Okay, I think we're getting it.
internal quotation marks omitted. Often, of course.
Okay, I'm not
10
going
Chiles
to
v.
turn all of this
Salazar.
to Obsidian until
Opinion of the court.
I've tested the portal.
A person disturbs the peace through conduct alone, say, by brawling at a city council
So disturbing the
meeting.
peace has to be physical. It
But
can't
that
be
is
words.
not always true.
The counselor's doing word. Oh,
And in Mr. Cohen's
Not
case,
always true.
California charged
He
him for
wore a
disturbing
jacket bearing the
peace
words, "Fuck the
because
draft."
He wore a jacket bearing the words.
all right, are we
"Fuck
good?
the draft" in the
Hey, we have a
corridor of
portal. Let's
municipal
roll.
courthouse. Ibid.
Oh my God, something's trying to kill me.
As applied to him.
Can I just sleep?
the
I'm
court
sleeping through the night. I have a portal set up. I'm sleeping through the night. I'm gonna take everything from the village in a second.
Because the only conduct he engaged in
We're
was
rolling.
the speech he displayed.
We are thoroughly rolling right now.
ID at 18.
Got more food. A potion of healing.
And
Oh,
we
instant
held
health. Huh.
California could
Interesting.
not constitutionally punish him because of the content of his MES Sage. Ibid.
Okay,
We
so
repeated
this
the
is
point in
fighting words have to be physical, right? Mr. Cohen's case, California charged him for disturbing the peace because he wore a jacket bearing the words, "Fuck the draft," in the corridor of a municipal courthouse. As applied to him, the court recognized the law implicated core First Amendment concerns because the only conduct he engaged in was the speech. As we held, California could not constitutionally punish him because of the content of his message, only if it meaningfully, disturbed the peace. Okay. I'm thinking this is a reasonable Supreme Court ruling, honestly.
Holder versus Humanitarian Law Project, 561 U.
With this in mind, I am now going to turn all of that
2010.
obsidian, all of that
That case
lava into
involved
obsidian.
a federal law banning the provision of material support to certain
Do you
foreign
wanna
terrorist
perish?
organizations.
you jerk.
ID at 8 to 9. Much as
What about
California had in Cohen,
so material
the
support to
federal
terrorist
government-
organizations is bad, right? We repeated the point. The case involved a federal law banning the provision of material support, well, monetary support, right, for certain foreign terrorist organizations. Much as California and Cohen, the federal government in Holder argued that the law did not trigger strict scrutiny because it addressed conduct and not speech. Interesting.
Government in Holder argued that the law did not trigger strict scrutiny because it addressed conduct.
Okay,
not
so
speech.
blocks of gold are huge because I can trade them in the nether for ender pearls.
26. We
Speed my way
disagree.
through all this crap way faster that way.
True, we acknowledged the law often might regulate conduct. But we observed, in the case
Oh, I kind of wish I
before
had
us,
like
the
a
government
place,
threatened
a
to
dumpster to
prosecute
throw all my
lawyers,
items I don't
doctors,
need.
and others for providing spoken training and expert advice, such as how to use humanitarian and international law to peacefully resolve disputes, to certain groups. ID at 16.
Yeah, let's make this a bigger
21
chest.
to 22. And that
Nice, more
application of
room.
the
I don't
law
have to do as much
we
thinking
held
about getting rid of
sought
garbage.
to regulate speech on the basis of its content.
Okay, we are
and
going
thus
to
demanded
that
strict
town real
scrutiny
quick.
Review.
Let's go.
ID at 27 to 28.
I need food. Hopefully they have some.
As Holder
They have farms. Good.
indicates, 2. The First Amendment's protect tie-ins extend to licensed professionals much as they do to everyone else. It's a point we have since discussed at length in NIFLA.
Potatoes are nice.
There, California sought to require crisis pregnancy clinics to make certain statements to their
There we go.
clients.
We're rolling. We have infinite bread now. We're
The
set.
state argued that its law did not trigger demanding First Amendment review because it sought to regulate
There's a
only
Fletcher in there,
professional
and I have
speech
some,
by state license holders.
emeralds, don't I?
585 U.S. at 766 to 767. We rejected that move by compelling clinics.
This is a good village.
607 U.S. ______.
I mean, it could have more.
2026.
You could have more
Opinion of the
chests,
court.
but whatever. What are you? What is this
11.
item? Upgrade gear. No, I don't understand
To
that.
speak the state's message, the law regulated speech based on its content. ID at 766. And we held California had failed to identify a persuasive reason for treating professional speech as a unique category, exempt from ordinary First Amendment principles. ID at 773. In reaching that conclusion, to be sure,
Beetroot
we
seeds. I don't even know what to do with a
acknowledge
beetroot
two kinds of content
in this game. I
based
genuinely don't know like any
restrictions
recipes
can
that
apply to
involve beetroot.
professional speech without triggering strict scrutiny.
That's just me though. I'm dumb.
First, courts generally deploy less searching review when faced with laws that require speakers to disclose only FAC tool, non-controversial information in commercial speech. ID
Weird.
at 768. Zauderer vs. Office of Disciplinary Counsel of Supreme Court of Ohio, 471 U.S. 626.
Let's get it.
650 to 653.
Going to the nether.
1985.
How long have I been playing?
Second,
Actually, don't know. Like an
laws
hour?
regulating conduct
76
in
minutes.
ways that
An hour and a little
incidentally
more.
sweep in speech may also
Okay.
generally avoid strict scrutiny.
Big potato time.
NIFLA
Turn this
585
into
US
this.
at 769.
That is a bunch of bread.
As
I used
with
it correctly,
laws
I could
address
probably beat the game with
ING
this much food.
fraud, defamation, and
I did not need
fighting
that. Go away.
words,
Go away.
laws regulate.
Make the book go away.
ING speech along these two lines enjoy a long historical
Addition.
tradition.
Yeah, I've heard that
ID
before.
at 767.
Okay, gold's gonna go down here.
But we stressed
Uh,
neither
3 gold
turn
blocks
S
is pretty
on the
good.
fact that a licensed professional happens to be speaking. ID
Okay.
at 768.
Alright, what could we need when we get into the nether?
Nor, we
Some sandstone,
emphasized,
some
do
cobblestone. I'll just take
these narrow
sandstone for now.
categories of lesser protected speech warrant a new rule exempting a broader
Need to make sure I do not
called
take any of my
professional
armor
speech
when I first go
from
in.
demanding First Amendment review. IBID.
I think I'm gonna take nothing into the nether at
B.
first. Truly nothing. 2 baked potatoes. That's what I'll
Applying
take.
these
Okay, let's go.
principles, we conclude that the
Remember to
courts
set my
below
respawn point.
failed to
Wonderful.
apply
Alright, let's jump in.
sufficiently
We're gonna jump in,
rigorous
we're gonna
First
die, that's
Amendment
it.
Scrutiny in this case. Start with the most obvious point.
Okay, let's go.
While
We're
the
running.
First
We're running.
Amendment
Our goal is to
protects
cover ground
many
and look for a
varied
thingy.
forms of expression, the spoken word
Okay, so
is
we're doing this
perhaps
again.
the quintessential form of
Video
protected
settings.
speech.
I need to make my field of view
And
wider.
that is
I don't remember
exactly
how.
the kind of expression in which
Wider.
Ms. Chiles
I'm gonna turn
seeks to
down
engage.
my light. Oh,
As
dear
a
God.
talk therapist, all Ms. Chiles does is speak with clients. She does not prescribe.
Down my mouse. Uh-oh.
12 Chiles v.
All right.
Salazar.
Mic is back up.
Opinion of
We're
the
good.
court.
But we're dark for the time being because I need to be able to see better in the
Medical
nether.
devices, or employ any physical
Brightness, bright.
methods.
Ugh, I wish I could get it brighter.
App
Okay.
205A.
All right. Wider field of view so I can see. I don't know where I got these 3 blocks of dirt, but whatever.
Colorado seeks to regulate the content of Ms. Chiles's speech. When it comes to issues
I can make a
of
buddy
human
from this if I
sexuality,
rehydrate him, I think.
some of her clients
I just don't remember how he
are
works.
content with their sexual
No way.
identity and
Is that...
orientation and
No,
want
it's not.
help only
Okay.
with social issues or family relationships. ID at 207A, 214A. But other clients seek her counsel on how to reduce or eliminate unwanted sexual attractions, change sexual behaviors, or grow in the experience of harmony with their bod, IES. ID at 207A. And in those cases,
Oh no,
Colorado
not good.
regulates how Ms. Childs
Oh, I
may
hear a
respond.
piglin
Under
that I
its
could trade
law,
with later.
she may not speak in any way that attempts to change a client's sexual orientation or gender identity, including a client's
This is the part
behaviors or
of
gender
the speedrun that I
expressions,
always end up losing the
or
game
in any
over.
way that
Because I just
seeks
can't get to a fortress in
eliminate
time.
or reduce a client's sexual
Need to be comfortable
or
just
aromantic
running around,
attraction or
losing my
feelings
gear,
toward individuals
dying a
of the
bunch.
same.
And searching for this
Sex.
stupid fortress.
Section 12,
It's like pretty much supposed to spawn like within a certain distance
202,
of you to make the game playable.
3.5a. Doubtless, Colorado sees things differently. The state insists, and the 10th Circuit agreed, that its law does not regulate expression
My neck.
at all,
Ow.
only conduct, treatment, or a therapeutic modality. Brief for respondents 2, 36 to 37.
So it's a fundamental disagreement on whether or not
47,
the law was written well enough to defend that
116F,
justification that it only...
at 1208.
The state insists, and the 10th Circuit agreed, that its law does not regulate expression at all, only conduct, treatment, or therapeutic modality. I mean, if that's the case, then the law should have been ruled constitutional. I guess I should have read the entire law that bans this. That might have been the right thing to do for this stream. Maybe it's something I'll do after this. On my own.
1208. As a result, Colorado reasons.
Yeah, I'm not trying to give myself
its
infinite.
law
Oh my
triggers
god, I
no
found
more
one. Are you
rational
kidding?
basis
How?
Or intermediate scrutiny review.
Oh my god, it's
Brief
gonna kill
for
me.
Respondents 42 to
Oh my god, I actually
44.
found a fortress in reasonable time.
But the state's premise is simply mistaken.
How do I remind myself the
In
direction to
many
go?
applications,
Do I just hope I'll
the
find it again?
state's law banning
That won't work.
conversion therapy may address conduct, such
No,
as aversive
what do I do
physical
now?
interventions.
How do I give myself a
But
clear
here,
marker
Ms.
that...
Childs seeks to engage only in speech, and as AP applied to her the law
I know I could
regulates
use,
what she may say.
whatever it's called,
Her
I can
speech
use,
does not become conduct just because the state may call it that.
if I wanted to,
Nor
I could
does her
use
speech
coordinates,
become
but I don't like using
conduct
coordinates.
just
I don't know.
because it
I've just
can
kind of
also
generally
be
decided against
described as
coordinates.
a treatment, a therapeutic modality, or anything else. The First Amendment is no word game.
I need to see this law, but like...
And the rights it protects cannot be renamed.
Shit! Okay, I made it. Alright.
Cite as
Keep going. Back the way I think I came.
S underscore
Even if it isn't the way I actually came, I can't remember.
underscore 2026.
It's one of the first times I've ever
Opinion
found
of the court.
Nether Fortress or whatever it is. Quickly, not a
13.
bastion, a fortress.
Away or their protections nullified by mere labels. NAACP button 371 U.S.
Come on.
415,
No, where did I spawn?
429,
That's probably super far away at this point. But if I walk it back, I might be able to
Our
remember
precedents have
how to get
long
there.
made that much clear. California faulted
Okay, I'm gonna
Mr.
check
Cohen
coordinates.
for the conduct of wearing an offensive jacket.
96, negative 52.
Cohen, 403
96, negative
U.S.
52.
At 16.
That's allowed, right?
The federal government insisted that its law banning support to terrorists regulated
96, negative
conduct,
52.
even as applied to the written and SPO
Is that my portal?
advice of
Holy crap, I
professionals
actually
like
have a chance of
lawyers
pulling
and
this off.
doctors. Holder, 500.
I know what direction it is. It's this direction now.
at
Reminded myself it's that direction.
10:26.
Oh my god!
But
I
the
flooded
effort
Fortress!
to recast speech as
In reasonable
conduct failed
time!
in those cases, and
Holy
it must
cow!
here too. Under the First Amendment, what matters is not
Okay,
how
what do
a
I do? I gotta
government
gear up, right?
describes its law or whether the
What am I
law
supposed to
may
do? So, like, I
regulate
put a gas
conduct in
somewhere.
other circumstances.
And then I put water over top of it?
What matters is whether,
It's
in
like a buddy?
fact, the law regulates speech in the case at hand.
I've never done this, I'm just doing this for fun.
As applied here, Colorado's law does not just regulate the content
Yeah, I
of
don't really
Ms.
know.
Childs'
Whatever.
speech.
Okay.
It goes a step
Alright, gear
further,
on.
prescribing what views she may and may not
Full gear.
express.
Take a bunch of
4A.
food with me.
Gay client, Ms. Childs may express acceptance, support, and understanding for the facilitation of identity
I'm not gonna take the gold. I don't want to risk the gold yet. It's not worth it.
Section 12, 245.
But what else can I take with me? That'll help me out. I'll need
3.5.
cobblestone to box in the fire thingies.
For a client undergoing
Instant health
gender
might be useful.
transition, Ms. Childs may likewise offer
Honestly, a door
words of
might help.
assistance. Section 12, 245, 202.
I don't really think there's anything else I need to take. I'll take dirt with me to label the way.
2.
And
But if a
torches,
gay or
I guess I can use
transgender
torches to
client
slow
seeks
down.
her counsel in the hope of ing his sexual orientation or gender identity, Ms. Childs cannot provide it. The law forbids her from saying anything that attempts to change a client's sexual orientation or gender identity, including anything that might represent an effort to change her client's behaviors or gender expressions or
Nope.
romantic
I'm gonna die.
attraction.
Can't risk it.
S.
Not right now.
Section 12, 245,
Sleep. Cool.
202, 3.5a. Colorado disputes none of this.
Okay, the law forbids her from saying anything that attempts to change a client's sexual orientation or gender identity, including anything that might represent an effort to change her client's behavior or gender expressions or romantic attractions. Colorado disputes none of this. That's what the law says. I agree with it personally. Now it is the dissent. The dissent also recognizes the law says that. I think is a complete rational. What is... Again, so they're really just sticking to you're interfering with speech, so it's an issue. Okay, alright, sticks made. We're gonna use up a bunch of our coal to make torches to get me there and back safely in a consistent manner. And I need to use up a piece of steel to make a shield, because I'm gonna need a shield to fight these things. Oh, not fair. Gotta keep it playing.
Neither does the dissent. See post at 20 to 21, opinion of Jackson, J. AC acknowledging that Colorado has engaged in viewpoint discrimination. Of course, Ms. Childs remains free to say other things. As Colorado and the dissent emphasize,
Ugh,
she may
I'm moving almost too
share
quickly for myself.
information about sexual orientation or gender identity. 14 Chiles v. Salazar. Opinion of the court. Brief for respondents 20. She can criticize Colorado's law. Ibid. She can writ papers espousing her views. Post at 20, opinion of Jackson, J. She may even encourage a client to seek advice from someone else who doesn't hold a state license. Brief for respondents.
Yeah, you can
20.
encourage like kids to consult
But
spiritual
true
leaders
as
and
all
stuff. That's
that may
legal.
be, it is also true that she cannot voice certain perspective.
You're kidding me. Leave me
the
alone, you
state
jerk.
disfavors when speaking with consenting clients.
Stop.
Rosenberger, 515
Leave me alone.
U.S.
I'll end you. Leave me alone.
829. And under our precedents,
Too many gas.
viewpoint
Far too many.
restrictions like that are not subject to mere rational
Nope, you
basis
jerks. I hate
review
all of
or
you.
intermediate
Leave me alone.
scrutiny. Rather,
Oh, the
they
nether's still so hard in this
represent
game.
an
What the
egregious
hell?
form of content discrimination, where First
Nope,
Amendment
too many,
concerns
too
are
many,
at their
too many,
most
too much going
blatant.
on.
Ibid. See
Instant
also
healing.
read 576 U.S.
Y'all suck. Leave me the hell alone.
168
Oh my god, did I hit them or did you hit them? Are they coming after me or them?
Post at 8:20 to 21. Jackson.
Do not tell me they're coming
J.
after me.
Dissenting, contending that heightened scrutiny is not warranted, even while admitting that Colorado's law discriminates based on viewpoint.
Y'all are idiots. You're about to hit the pigs again and get murdered.
The fact that the state's viewpoint regulation targets
Alright, well, now it's over for you, buddy.
only
Shouldn't have done that.
licensed
Now they're all
healthcare
angry.
professionals like Ms. Chiles changes nothing. Colorado and the dissent may believe that the First Amendment should carry far less salience for the nation's millions of medical professionals than for
Okay,
everyone
what
else.
direction now? Because I don't remember.
Post at 2. Opinion of
I only think I
Jackson,
remember.
J.
And it's like this way,
Post
isn't it?
at 17 to 26.
I'm gonna go for it, but I think
Brief
this is
for
wrong,
respondents,
actually.
23. They may believe that state-imposed
Oh my god, I do
orthodoxies in
actually see one on my
speech
dirt blocks
pose
from
few
earlier.
dangers
No
and
way.
many benefits in this field, and who knows what others. But their policy is not the First Amendment's. The Constitution does not protect the right of some to speak freely, it protects the right of all. It safeguards not only popular
Correct, the Constitution
ideas,
technically
it secures,
only
even and especially,
defends.
the right to voice dissenting views. Consistent with these principles,
Too much fire, what is all
our
this?
priest
Leave me alone.
dens have expressly rejected the state and
Okay,
dissent's
I'm gonna head this
notion
way
that
now, right?
professional
And it's
speech
over this
represents
hump.
some separate category of speech subject to diminished constitutional protect. Tie-in. NIFLA 585 U.S. at 767, internal quotation marks.
This way, right?
Omitted. History is littered with examples of official efforts. Cite as 670.
We're lost. We've
S
lost it.
Underscore.
Not good. You wanna leave me alone, bud? Because I'm gonna have to kill you otherwise.
2026. Opinion of the court.
I'll find more of you later.
15. To
Found it.
manipulate
Cool.
and
Huge.
control professional speech,
So let's
including the content of doctor-patient discourse, in ways
Oh my
designed
god, I
to
almost fell
increase
with all
state
this gear
power,
on me. Are you kidding me?
suppress minorities, and muzzle
What the hell is
unpopular
that?
ideas. ID at
Are we seeing this?
771,
Holy shit.
internal quotation marks omitted, recounting
Alright,
examples.
where's my last torch?
And the dangers associated with censorship we have recognized are no less
Would you
acute in the
I can't hear
fields
you.
of
What's going on?
medicine and
Would you like
public
a potato
health
now or
than
later?
they are
Sure, I'll
anywhere
eat.
else.
Just cheese.
Ibid,
Sure.
internal
Cheese and salt.
quotation marks omitted. Nor does Colorado's law implicate any recognized except tie-in to our usual First Amendment rules.
Okay.
As we have seen, some laws regulating speech based on its content, like
So
ones
I need a way to go
addressing
from
fraud,
here to the inside of the
defamation,
dang
and
thing
fighting
without
words,
dying.
do not generally trigger heightened scrutiny because of their long historical pedigree.
And I'm not sure what the
See Part
safest approach is going to
2A,
be long term
Supra.
here, because that is obviously
As
a
we
way
have
for me to
seen,
fall into a
too,
hole and die.
NIFLA recognized that two kinds of such laws sometimes apply.
Okay, we're about
to
1/3 through the
professionals.
document, and I am in the nether.
C585
And I have found a
US
nether
at
fortress or whatever.
768.
That's hopeful, but not perfect.
Colorado's law
Especially
fits in
considering I
neither
can fall to my
category.
death at any moment right now,
The state
based
does
on how
not
this is looking.
require professionals to disclose
But I really did not think about like
factual,
how I was going to get over there.
non-controversial information
I think
in their
maybe the logical
commercial
choice is to
speech.
just start digging through here, for
Ibid,
example.
internal quotation marks omitted. Instead, Colorado seeks to suppress views Ms. Chiles wishes to express. Nor, with respect to Ms. Chiles, does Colorado's law regulate conduct
Okay, if
in a
I were
way that
smart, I
only
would not do this right
incidentally
now.
burden
Because it's too risky.
speech. ID at 769.
Oh, this is just terrifying is
All
what it
Ms.
is.
Chiles does is speak, and, as far as she is concerned, speech
Life's
is
a
all
risk, you gotta take
Colorado
it.
seeks to regulate. Resisting this conclusion, Colorado and the dissent try to shoehorn the state statute into the latter category. See, e.g., Brief for Respondents 37. By defining prohibited conversion therapy broadly, Colorado observes, its law
Fortress, I'm in.
proscribes
I made it into a
wide
fortress.
range
Holy
of
crap.
treatments. ID
Okay.
at
Alright, now
18.
I need to protect this
Any
route so I can
activity
never
that
fall.
seeks to change a client's gender identity or sexual orientation, whether it involves electric shocks or consists of words only, is banned. Ibid. And considering the full scope of the law's many applications, the state
Wow,
sub
what a terrifying thing I'm
admits
doing right
it
now.
seeks to regulate mostly conduct and reaches speech only incidentally. Ibid. The dissent pursues a similar 16 Chiles v. Salazar. Opinion of the court.
You know what makes me an idiot? What makes me an idiot is not taking
Theme,
wood with me to build a
insisting
damn
that
box.
Colorado has only incidentally prohibited
When I'm
Ms.
clearly going to be
Chiles's
killed
speech
momentarily.
because the law's primary objective is to regulate medical treatments. Post at 8 to 26. Opin Ion of Jackson, J. This argument echoes Colorado's claim that it seeks to regulate only conduct, and they falter for similar reasons. If a government could reclassify talk therapy as speech incident to conduct, it might just as easily do the same for speech incident to teaching or protesting. Otto, 981 F3D, at 865.
I have reason to head that direction, so.
B. Author activities, after all. Ibid were that the rule, W, had an opportunity for suppression of dissent this would offer.
Keep rolling.
116 F 4th at 1228 Hearts, J.
Oh, it's enough diamonds to
dissente.
make a pickaxe if I felt like it.
Governments could easily wield
Okay,
all
we're gonna
manner of
use
laws
the
regulating some
right hand
conduct to
maze
silence
rule.
speech they disfavor. It is a
Disfavor.
result that would not comport with the First Amendment's animating principles so much as betray them. Contra, post, at 17, Jackson,
Did I take
J.
that? Okay, I did.
dissenting.
Okay, and we're gonna use
Recognizing as
this
much
to block
our
off
precedents
hallways.
in Cohen and
To make it obvious I don't want to go in their
Holder already
directions.
foreclosed exactly
Okay.
this move.
I already see what's going
California prosecuted
following the
Mr.
right-hand
Cohen
rule.
under a law banning disturbances of the peace. Cohen, 403 U.S.
Huge.
at 16.
These are good for fire resist potions, if I
The
can remember how to
federal
make them.
government
But you would need,
threatened
I'd need
lawyers and
magma slimes.
doctors with prosecution under a law prohibiting support
Okay, I'll make
for
these just in case I need
terrorists.
them.
Holder, 561 U.S.
I hate being in the
10,
nether because it's so
14
hard to
to
see.
15,
It is so genuinely,
25.
seriously hard to see.
In both cases,
Okay, that's enough
the
soul sand to
government
do what I
defended
might
its
want to.
actions on the ground that the law in question was general ally aimed at certain types of
Okay.
conduct. But in both cases, we emphatically
Keeping up with the
rejected
right-hand
that
rule.
argument. Just because a law may
Okay, am I about to be
generally
outside?
functio and
Alright, I
as
see a spawner.
regulation of conduct,
That kind of sounds like a
we
spawner
held,
too, but I'm not
does
sure.
not exempt it from demanding
Found a
First
spawner?
Amendment review
It
when
looks
a
like it's
government
disconnected
seeks to
from other
apply
parts of the
that
fortress.
law to speech alone. ID at 27 to 28. At bottom, Colorado.
That looks
and
pretty
the dissent
tolerable to me.
Fundamentally misconceive this court speech
Nope.
incident to
Oh my
conduct
god, this is gonna be
pre-stance.
brutal. Absolutely
In
brutal
these
is what this is gonna be.
cases, the question is
Okay,
not
we're gonna
whether a
go
law
here
mostly addresses conduct and only
and
sometimes
block it
sweeps in
off, essentially.
speech.
We are instead going
the
to take a
focus
left here.
lies on two entirely different.
Oh, and look, yeah, it went straight through anyway.
Cite as 607 U.S. underscore.
Okay, I want what's in that box.
Underscore 2026.
Hopefully my
Opinion
greed
of
doesn't
the
get me
court.
here, because that is a fault to my death if I fuck
17.
up. That was not worth it. Another wart was not worth it either.
Whether the law in question restricts speech only because it is
Okay, don't get
integrally
lost, don't get
related
lost.
to unlawful conduct, or whether the law restricts expressive conduct only for REA sons unrelated to its content.
Cool, thank you.
Illustrative of the first category, this court has held that strict scrutiny does not apply to regulations aimed at speech promoting the sale of contraband because such speech is often bound up with traditional criminal conduct. United States v. Williams, 553 U.S. 285, 297 to 298. 2008. See also Gibney vs. Empire Store Age and Ice Company, 336 U.S. 490, 502.
The game's getting
49.
Game's getting scary.
For Eugene Volokh as Amicus Curiae 3 to 11. Illustrative of the second category, an ordinance against outdoor fires would not require a court to apply strict scrutiny even if it prohibited burning a flag in protest, because the law forbids conduct without regard to the message it may convey.
Yeah, I see the general direction
Sorrel v.
that it kind of wants me to head.
IMS Health Incorporated, 564 U.S. 552, 567, 2011. Colorado's law does not regulate speech incident to conduct under either test.
Ants don't?
The state does not dictate what Ms. Chiles may say because her speech bears a close causal connection to some separately unlawful conduct like a traditional crime.
It's up there somewhere.
Rather,
I just don't know
Ms.
where.
Chiles seeks to speak with interstate clients
Ooh,
about
this music is
steps they
getting
might take to
dramatic.
change unwanted behaviors,
The rise, the
expressions,
swell.
or attractions related to sexual orientation or gender identity. Conduct Colorado itself does not
Stop that.
dispute those clients.
Okay, it's
or
there.
anyone else
I need to get into there.
may lawfully undertake. CFTR
So it's more
of
like
Oral
here,
Art
I guess?
58, conceding that life coaches and other non-licensees can lawfully convey the advice Ms. Chiles seeks to offer. Nor does Colorado seek to regulate Ms. Chiles's speech for reasons unrelated to its content, like a ban on outdoor fires that happens to sweep in flag burning. Instead, the state's law trains directly on the content of her speech and permits her to express some viewpoints but not others. Colorado does not regulate speech incident to conduct, it regulates speech as speech. NIFLA, 585 U.S. at 770. 18 Chiles v. Salazar. Opinion of the court. C. Perhaps sensing
Wow, what
that
I'm
this
currently
court's
hearing is
existing
terrifying.
precedents ferret little support, Colorado ultimately pivots, urging us to reshape our doctrine. In doing so, the state begins by
Holy cow, this is scary.
again to NIFLA. There, recall, the court observed that our cases have identified two circumstances in which speech by professionals may warrant diminished First Amendment protection, when a law seeks to compel disclosure of factual, non-controversial information in commercial speech, and when a law regulates speech only incidentally to conduct. ID at 767
Oh my god, I'm beneath it.
to
No way.
768.
Okay.
Internal quotation
Holy crap.
marks omit TED.
Okay, so we're
Still,
gonna use the stair-step
Colorado
method to get up.
emphasizes, NIFLA left open the possibility that a future party might present persuasive evidence of a long, if heretofore unrecognized, tradition of content regulation regarding additional categories of professional or other speech that might likewise warrant only diminished First Amendment protection. ID at 767 in.
Okay,
Internal
wow.
quotation marks omitted.
I'm about to lock
See
in.
also
This is
United
gonna really
States
determine the run.
Stevens, 559 U.S. 460, 472, 2010. Seeking to take up this challenge, Colorado contends that its law falls within a long tradition of permissible content regulation. It's a line of argument that comes with a daunting burden. Under our precedents, the state must present persuasive historical evidence in order to overcome our especially reluctant CE to mark off new categories of speech for diminished constitutional protection. NIFLA 585 U.S. at 767, internal quotation marks omitted. Still, Colorado insists it can carry that burden in this case because states have traditionally enjoyed wide latitude to prescribe substandard care even when that involves regulating the content of speech. Brief for respondents 16. As
I mean, keep
evidence,
it clear.
Colorado points to the history of state
Conversion
laws
therapy is not just
licenses
substandard care,
ING
it's abuse.
the practice of medicine, regulating informed
It's like full
consent,
proper
and
abuse.
permitting tort suits for medical malpractice. ID at 23 to
I honestly need to find a
36.
better way to do this.
The dissent pursues the same point, citing the same authorities. See post
Shit.
at 9 to 11.
This is so hard. These things are
26 to
so
31,
impossible to fight
35,
without fire
opinion.
resistance potions.
Cite as 607 U.S. underscore 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 2026. Opinion of the court. 19.
Oh my god. If I had some freaking wood on me, I would just make a dang ladder up to them
Suggesting
instead.
that states may
But this
ban
is
substandard
such a bad
care
angle to come at them
provided
from.
via speech in light of licensing, informed consent, and malpractice laws.
Okay, try this again.
This argument stumbles out of the gate, for it proceeds at far too high a level of generality. From three specific sets
Oh my god,
of
I really am underneath it.
Colorado, and the
Go away.
dissent ask us to recognize a cavernous First Amendment free zone. Stevens, 559 U.S. at 400.
But maybe I can just lure them down here?
Internal quotation marks omitted, one in which states may censor almost any speech they consider substandard care. It is, once more, an approach our precedents already foreclose. Consider a couple examples. In Alvarez, the federal government pointed to specific.
There's no way I can get
historical
enough
laws
from just this.
prescribing
I need
fraud and
a lot.
defamation and asked us
It's
to
only 4.
extrapolate from them a much broader rule allowing it to enforce content-based restrictions on any false statements. In NIFLA, California suggested that informed
That's my
consent
issue. That is
laws
genuinely
and our
my issue right
speech
there, is that I
incident to
cannot-
conduct doctrine might
I cannot get high
be
enough to like even just build a way out where I
together
don't
to
die
sustain
instantly.
the recognition of a field of
Okay,
profession.
let's do it. Let's do it. Let's do it. Let's get
subject only to rational
dip, duck,
basis
and diving and
review.
dodging.
We rejected both efforts,
Oh my God, look
stressing
at what I'm about
instead
to face. That
discrete
looked
traditions of
horrifying.
Content-based regulations cannot be aggregated together to sustain some new
Well, how do I
and
even
broader
approach this
category
genuinely?
of lesser protected speech. Alvarez, 567 U.S. at 718 to 722, plurality opinion, ID.
You
at
assholes, I swear to God.
736, Breyer, J. Concurring in judgment, NIFLA.
Or maybe I can just kill enough the
585
old-fashioned way.
U.S. at 767 to 768. See also button.
Oh my God, I see a freaking
371
whatever you call it over there.
S at 439
A wither skeleton.
to 440.
Oh, please stop. The knockback is so
Distinguishing states'
bad.
law from laws prescribing
The knockback is so
accepted
bad.
Common law offenses. Florida Star versus B. J. F. 491 U.S. 524, 539, 1989, similar. And Colorado's similar effort can succeed no more than others like it have in the past. Beyond that problem lies another. Taking each of the three traditions Colorado and the dissent invoke on its own terms, as we must, none delivers the support they suppose.
Oh yeah,
Start
see,
with
that's an issue.
Colorado's suggestion,
That's just me falling
endorsed by the
into my death.
dissent, that the state
Also,
statute
I'm about to
represents
run
nothing more than
out of that
20
fundamentally important
Chiles
thing that
v.
I need.
Salazar. Opinion of the
We're
court.
just gonna build like crazy. Build like crazy.
A traditional law licensing the practice
Nice try,
of
idiots.
medicine.
Okay, let's do this.
See brief for respondents 27 to 28. Post
Hey.
at 26 to 27.
We're so cooked.
Opinion of
Oh my
Jackson,
God, I don't have
J.
the right materials to get home.
We cannot agree for at least two
Uh.
reasons. First, the state has not
Holy
presented
crap, what do I
persuasive
do?
evidence that its law is part of a historical tradition.
Oh my God, that was
When
it.
says
That was it. That was all I
the level
had.
of generality our precedents demand. What Colorado describes
no way.
turns out to be a relatively recent innova tie-in. Indeed, the briefing before us suggests that the very first state counselor licensure bill was adopted
that hurts.
only in
That hurts a lot.
1976. National Academies, Institute of Medicine, provision of mental health counseling services.
Okay, so now I
under
have to get back there and get all the gear I just had.
2010.
And I have to do it without
D.
dying?
Bergman, the role of government and lobbying in the creation of a health profession. The legal founder tie-ins of counseling.
A silk-tucked pickaxe is
91J,
kind of insane.
Counseling and Development 61.
Can I use that to move the
2013,
spawner for these guys?
Bergman.
I don't
See
know.
also brief for petition.
Okay, but what else can I take with me? Wood is something at
And
least.
that is far from the sort
A
of
sword might help.
persuasive evidence.
And obviously,
of
the
a
thing I forgot
historical,
was a freaking pickaxe.
grounded practice our precedents require. NIFLA 585.
Let's do it. That's all I got. All I have is what I have. We gotta go.
US at 767.
I have to get back there somewhere. Somehow not die.
Internal quotation marks omitted.
Okay.
Second, licensing laws have traditionally
been
addressed
20
what
seconds and I'm already being
qualifications an individual must possess before practicing a particular profession. See Bergman 62, licensing laws generally establish H, minimum standards of preparation and insert E, the professional is qualified, are cry, the watchman for truth, professional licensing and the First Amendment, 23 Seattle U, L, Rev 885.
Come on, get it.
887.
Wow, that was
2000.
horrifying.
Licensure scheme typically sets out certain requirements that the professional must fulfill before practicing. And whatever traditional interest a state may have in ensuring a professional possesses
Crazy,
a
all of this
particular
is
set
crazy.
of qualifications, that interest does not automatically entail a right to dictate a professional's point of view. NIFLA 585 U.S. at 700.
Okay, I'm happy I set this up this way though, so
Turn
I
now
can get
to
back quickly.
Colorado's effort, again echoed by the dissent, to compare its statute to informed consent laws. C. Brief for respondents 34 to 36. Post
Okay, I
at
died
9
in my
to
hole.
11.
That is perfect.
Opinion of.
That works out. That works out. I'm okay with this outcome. This is an okay outcome.
Those laws generally require a doctor to inform a patient about the nature of a proposed procedure.
Okay, there is another.
Cite as 607 U.S. ____.
Nope, I made a mistake. I made a
_
mistake. I have made a mistake.
2026.
Not good, not good, not good.
Opinion of the court. 21.
No, hey, bud, what's up?
And its attendant risks.
I only have 4 blaze powders.
Niflin 585
Oh my god. I thought Silk Touch maybe would let me take the spawner.
770. Internal quotation marks omitted.
Shit, shit, shit.
As such, informed consent laws do
Wow,
not
that's
usually
bad.
trigger strict scrutiny
That's actually
because
like a
they
notably
regulate
bad
speech
outcome.
only incident
That
to
I just hit one of
separate
those by
physical
accident finally.
conduct that would, without
Oh no.
the
I don't know how long it takes
patient's
for that to wear
consent,
down.
amount to an assault.
How long does that take for it to wear off? I don't know.
At 770, internal quotation marks omit TED. Usually, 2. Informed consent laws require practitioners to disclose only factual and
Okay, I see like
uncontroversial
1,000 flames this
items.
direction. I see a skeleton that wants to kill me.
CID at 769 to 770. But all that is a far cry from how Colorado's law operates here. As applied to Ms. Chiles, the state seeks neither to regulate her speech incident to any conduct, nor does it seek to compel disclosure of factual and uncontroversial
Wow, so
information.
I might have just made a bad mistake, but whatever.
Instead, it seeks to silence a viewpoint she wishes to express. Colorado and the dissent close by asking us to analogize the state's law to traditional tort malpractice claims. C. Brief for respondents 25 to 26. Post at 27 to 29. Opinion of Jackson, J. But here again the differences are impossible.
Well, the game really
to
is just
ignore.
not being nice to me today, is it?
In a traditional malpractice action,
By that, I mean I'm just
liability
kind of
attaches
sucking
only
right
if
now,
the
honestly.
plaintiff shows, among other things, that he has suffered an injury caused by the defendant's breach of the applicable duty of care.
Alright, screw it. Let's get up there.
C.E.G. Day versus
We're up here now, and
Johnson,
it's time to deal with it.
255p, 3D 1064, 1068 to 1069, Colorado 2011. Those kinds of
Okay, I think I might have killed like the only location of those that I have, because this one is not. Oh, it is. I'm set.
Breathing room for protected speech. Illinois ex rel. Madigan versus Telemarketing Associates Incorporated. 538.
Oh, eat! Nope. Lock
600,
in, lock
620, 2003. Yet Colorado's law contains nothing like them, instead threatening individuals with
Holy
fines,
crap. Okay, we have a chance.
probatorium,
Again.
and
We
the
have one more
loss of
chance.
their licenses
One more.
simply for expressing a
That's all we get.
particular view.
Okay.
See sections 12, 245, 202, 3.5, 12, 245, 224, 1.
Oh no, that's the
12,
abyss. That is.
245, 225.
That's not good.
Nor does Colorado's law allow clients to consent to practices that depart from the prevailing standard of care, while malpractice law sometimes does. See Re. Statement, 3rd, of torts.
Oh, this is
Medical
horrifying.
Malpractice,
Sometimes
Section
this game is
11,
just scary.
2024. Schneider versus Revisi, 817F, 2D.
Oh my god, I have a couple of torches left. Huge. Big difference.
995, CA2 1987.
They just won't even let me get close.
22 Chiles v.
I can't even
Salazar.
get close to these things. Oh, there's 1,000 of
Opinion
them.
of the court. Consider,
How do I even
too,
approach this right
where
now?
the state and dissent's logic leads. Not long ago, many medical experts and organizations, including the American Psychiatric Association, considered homosexuality a mental disorder. See American Psychiatric Association, Diagnostic and Statistical Manual of Mental Disorders
DSM-5?
38 to 39,
Back in 1952?
1952, cf. American Psychiatric Association, Position Statement on Homosexuality and Civil Rights, 1:31 a.m. J. Psychiatry 497, 1974. On the view Colorado and the dissent advance, a law adopted during that era prohibiting counselors from engaging in the substandard care of affirming their clients' homosexuality would have been subject to only rational basis or in term diet scrutiny review, and likely upheld. See 116F, 4th, at 1237 to 1238, Hartz, J. Dissenting. Today, tomorrow, and forever. 2. Any professional speech that deviates from current beliefs about the safety and efficacy of various medical treatments could be silenced with relative ease. Post, at 24, opinion of Jackson, J. It is a consequence. Colorado freely acknowledges. TR, of Oral Arg 61 to 63. And one the dissent embraces. Post
Stop, leave me alone.
at 23 to 26, and N9, opinion
my God.
of Jackson, J. So what if that kind of reflexive deference to currently prevailing professional views may not always end well? CF Buck vs. Bell, 274 U.S. 200, 205 to 207, 1927. Fortunately, that is not the world the First Amendment envisions for us. Licensed professionals have a host of good faith disagreements about the prudence and FICS of various practices in their fields. NIFLA 585 U.S. at 772.
Let's get it. We're almost there. Okay, huge.
2 is not static.
Massive
It
progress on
evolves
that
and
front.
always has. A prevailing standard
Nice,
of
I
care
killed
may
one.
reflect
Nothing
what
dropped,
most
though, which sucks.
practitioners believe today,
I have a
but it
singular
cannot
torch
mark
left.
the outer boundary of what they may say tomorrow. Far from a test of professional consensus, the First Amendment rests instead on a simple truth. He people lose whenever the government transforms prevailing opinion into enforced conformity. Ibid. Cite as 607 U.S.
Okay, no, I see what's going on now, just barely. We still need to climb up.
2026. Opinion of the court. 3. 23. We do not doubt that the question, how best to help minors struggling with issues of gender identity or sexual orientation is presently a subject of fierce public debate. Tim Glay v. Ferguson, 601 U.S.
What's the method then?
Underscore 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 2023. Thomas J. Dissenting from denial of certiorari, slip-up, at 1. But Colorado's law addressing conversion therapy does not just ban physical interventions.
I think the right thing to do for now
In cases like this,
is
it
to build a
censors
chest.
speech based on viewpoint. Colorado may regard its policy as essential to public health and safety. Certainly, censorious governments
we're gonna
throughout
take most of what
history
we've
have
gotten.
believed the same.
Set it aside for now.
But the First Amendment stands
Let myself
as
die a few
shield
times
against any effort
just be
to
okay with it.
enforce orthodoxy in thought or speech in this country. It reflects instead a judgment that every American possesses an inalienable right to think and speak freely, and a faith in the free marketplace of ideas as the best means for discovering truth. However
They're getting my ass. They're getting my
any
ass.
law that suppresses speech based on viewpoint represents an eager, joyous assault on both of those commitments. Rosenberger, 515 U.S. at 829. The judgment of the
Yeah, doing
Tenth
that with one
Circuit
heart
is
was kind of
reversed,
stupid.
and the case remanded for further proceedings
Oh
consistent
shit, it's really
with
gonna
this
kill me.
opinion.
God damn it. If it gets
It
my
is
chest, that's
so
bad too.
ordered. Cite as 607 U.S. underscore
Okay, I gotta eat
underscore
first.
underscore underscore 2026.
I am not safe. Huh.
Kagan, J. concurring. 1.
Holy cow. So this is now a concurring
Supreme Court
opinion.
of the United
We're halfway through.
States.
I don't know if we're making it or not.
Underscore 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 number 24 to 539 underscore 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 Kaylee Chiles, petitioner v. Patty Salazar, in her official capacity as Executive Director of the Colorado Department of Regulatory Agencies, ETAL. On writ of certiorari
Oh,
to the
it
United
almost knocked
States
me.
Court
Holy
of
cow.
Appeals for the 10th Circuit.
This
March
is, I'm
31st,
in a war zone right
2026.
now. This is terrible.
Justice Kagan, with whom Justice Sotomayor joins, concurring. The court today decides that the
Holy
Colorado
cow.
law challenged here, as
I already pretty
applied
much have to go
talk
back and get food
therapy,
at this point.
conflicts with core First Amendment principles.
I have to find a way to
because
not
it
die in the
regulates
process.
Speech based on viewpoint. See ante at
Okay.
23. I agree. I write only to note that if Colorado had instead enacted a content-based but viewpoint-neutral law, it would raise a different and more difficult question. As the court states, governments must, nearly always, abstain from adopting viewpoint-based restrictions. Ante, at 9.
Fuck all y'all. Get out of my way.
Those laws represent a
Yep,
particularly
30 of you attacking me at the same
egregious
time.
form
Not fun.
of content-based regulation, implicating First Amendment concerns to the highest possible degree.
Maybe I need to swap to a sword because it has further reach.
Ciancu
I have no other food on me. This sucks.
Brunetti,
This stinks.
588
This truly stinks
S
right now.
388, 393, 2019. A law drawing a line based on the ideology of the speaker, disadvantaging one view and advantaging another, skews the marketplace of ideas our society depends on to discover truth. Rosenberger v. Rector and Visitors of University of Virginia, 515 U.S. 819, 829. 1995, and such a law suggests an impermissible motive. That the government is regulating speech because of its own hostility toward the targeted messages. R. V. V. St. Paul, 505 U.S. 377, 386. 1992. If the First Amendment. 2 Chiles v. Salazar. Kagan, J. concurring. Prohibits anything, it is the official suppression of ideas. ID at 390. C. Reed versus Town of Gilbert, 576 U.S. 155, 181, 183, 2015. Kagan, J. Concurring in judgment. Because viewpoint-based laws always
they're
raise
jerks,
that
you know that?
specter, they are the most suspect of all speech regulations. So much so that this court has refused to permit viewpoint discrimination even within unprotected categories of speech, like fighting words or obscenity. CR-V.
Okay, that's it. We're letting them kill us.
505
And then we're
US
going for it.
at 384 to 390.
Okay, I'm gonna let them kill me.
Colorado's law, as applied to talk therapy, regulates
This
based on
pickaxe is not actually that
for
important.
the reasons the court
I'm low on health, I
gives.
simply have to lose.
See ante at 13 to 14.
I suppose I should leave myself a way to
The law
get back in.
forbids a counselor to provide their AP designed to change a minor's sexual orientation or gender identity.
Alright,
Colorado
Free bird.
Reverend Stat
that's
Section
ball.
12,
Okay, wow. Yeah,
245,
that sucked. That definitely sucked.
202,
That did not work at all.
3.5,
Is there any... Is there like snow near me anywhere in the
See
game?
Section 12, 245.
Could use snow to fight these things way faster.
1 TV.
Suppose not.
At the same time,
Okay, take a
the
bunch of
law
food with me, keep trying.
specifically allows a
all I
counselor
can do.
to offer therapy expressing a
16 bread,
acceptance,
sure.
support,
Carrots.
and other affirmation of the minors. Identity exploration.
Here we go, 24 bread.
Section 12.
I should be able to get there by hand.
202, 3.5, B, I, 2. So, 4. Example. The law prevents a therapist from saying she can help a minor change his same-sex orientation, but permits her to say that such a goal is impossible and so she will help him accept his gay identity. Colorado does not dispute that point. CTR of Oral Arg 78. Nor does it dispute that under normal First Amendment principles, that difference constitutes viewpoint discrimination. See IBID. Indeed, the case is textbook. The law distinguishes between two opposed sets of ideas, the one resisting, the other reflecting, the state's own view of how to speak with minors about sex UAL orientation and gender identity. Iancu, 588 U.S. at 394. Or said just a bit differently,
We're kidding.
the law draws a line based on the speaker's opinion or perspective, and thus enables speech on only one side, the state's preferred side, of an ideologically charged issue. Rosenberger, 515 U.S. at 829, McCullen v. Coakley,
Hey, looks like I mostly remember
573 U.S.
what to do. I think I might just do like 10 suicide runs until I can box these guys in better.
Of course,
I think it's what I should do, but instead I'm just gonna fight.
Preferred.
Whatever.
Side is. Consider a hypothetical law that is the mirror. Cite as 607 U.S. underscore
Yeah, I've got all I can for now.
underscore underscore 2026.
Oh shit, no way.
Kagan, J. Concurring. 3. Image of Colorado's. Instead of barring talk therapy designed to change a minor's sexual orientation or gender identity, this law bars therapy affirming those things. As Ms. Chiles readily acknowledges, the First Amendment would apply in the identical way. CTR of Oral Arg 2526. See also ID at 37 to 38, United States as amicus curiae agreed. Once again, because the state has suppressed one side of a debate while aiding the other, the constitutive
Oh
issue is
shit, there we go, I'm
straightforward.
dead.
It would,
Oh, and there's a
however,
freaking
be
skeleton
less so if
too?
the law
How?
under review was content-based but viewpoint
How?
neutral.
This game is so hard.
Such content-based
Oh, I'm losing
laws,
it. I'm
as the
totally
court
losing it.
explains,
Oh
trigger
my
strict
god, I'm
scrutiny,
just actually losing it.
as a general rule.
Holy crap, it's like the
at
game's getting
8.
harder.
But our precedents respecting those laws recognize complexity and nuance. We apply our most demanding standard when there is any realistic possibility that official suppression of ideas is afoot, when, that is, a merely content-based law may reasonably be thought to pose the dangers that viewpoint-based
So in concurring, they're
laws
saying, if you had just written this
Ways
slightly
to-
differently, this probably would have been fine.
Davenport versus
Again, it sounds like
Washington
Colorado just
Ag
need to write this differently.
Association, 551 U.S. 177, 189, 2007. See Supra at 1-2.
Oh,
But
if I
when
just
that
had a
is not
single
the
fire
case,
resistance potion,
when a
I could
law,
just
though
get this
based
dealt
on
with really
content,
quickly.
raises no real concern that the government is censoring disfavored ideas, then we have not infrequently our guard. Read 576 U.S. at 183, opinion of Kagan, J. C. Davenport, 551 U.S.
That
at
works out.
188, noting the numerous situations in which the risk of a content-based law drive ing certain ideas or viewpoints from the marketplace is attenuated or inconsequential, so that
I swear to God, I'll end you.
unwarranted.
All of
Just
you.
2 terms
All of you. Every
ago,
last one of you
for
sucks.
example,
You
the
suck a
court
lot.
declined to apply
Yeah,
strict
I know.
scrutiny
I know
to
you're still hitting me.
content-based
Go for
but
it.
viewpoint-neutral trademark restriction.
Crap.
See Vidal versus Elster.
Can I hit this with a couple of these and it might help?
286, 295, 2024, ID, at 312, Barrett, J. Concurring in part, ID.
You
at
jerk.
329
Gotcha.
to 330.
Holy
Sotomayor,
cow. This
J.
sucks.
Concurring in judgment. In the trademark context, as in some others, experience and reason alike showed no significant danger of idea or viewpoint bias. R.V.
Keep moving, keep moving, keep moving. That's all I can do.
S at 388. For Chiles v. Salazar.
I have 4 more rods? That's
Kagan,
huge.
J. Concurring.
8? Oh, I
The
technically
same
have the
may
12
well
I
be
need.
true
I
of
technically have the
content-based
12 I
but
need. Oh, great. Here we go.
viewpoint-neutral
This
laws
again.
regulating speech in doctors' and counselors' offices. Asterisk medical care typically involves speech, so the regulation of medical care, which is, of course, pervasive, may involve speech restrictions. And those
Holy crap, we're actually
restrictions
making
will
progress just by
generally
virtue of
refer
me
to the
fighting them
speech's
so often.
content. Cf.
Holy cow.
Read 576 U.S. at 177, Breyer, J.
There's too many of
Concurring in
them.
judgment,
Way too
noting
many.
that
I'll have to lower them down here for now.
programs
Come on.
addressing speech inevitably involve content discrimination. But laws of that kind may not pose the risk of censorship, of official suppression of ideas.
Oh, why is this game so hard?
Our most rigorous review.
Jesus, Minecraft, what are we doing right now?
505 U.S.
Look at this, I'm just getting destroyed.
390. And that means
They're
the
genuinely
difference
jumping me.
between viewpoint-based and viewpoint-neutral content discrimination in the healthcare context.
I'm not really sure how much that'll help me.
Decisive.
I just hope it does.
Vidal, 602 U.S. at 330. Opinion of Sotomayor, J. fuller consideration of that. Question, though, can wait for another day. We need not. Here decide how
Just
to
one or
assess
two more
viewpoint
rods would be
neutral laws
preferable,
regulate
and then I'd be
ING
fine.
Health providers' expression because, as the court
Holy
holds,
cow.
Colorado's is not one. Asterisk Justice Jackson's dissenting opinion claims that this is a small, or even non-existent, category. See post, at 21 to 22, and
Wow,
8.
okay. I don't know if I have enough health right
But
now.
even
I don't know
her
if
own
carrots will help.
opinion, when
more than
listing laws supposedly put
straight
at
up
risk
bread.
today,
I don't think so.
offers quite a few examples. See
There we go.
post
Come get me.
at 32 to 33 and N13.
Nothing.
Her view
It
to
would have
the
been nice if it had
contrary
something, but it has
rests
nothing.
on reimagining, and in that way collapsing, the well-settled
I see a rod. I see a rod down there.
viewpoint-based and other
I just have to run up,
content-based
not
speech
die,
restrictions.
and then run up again.
See e.g.
I'd even just take the one rod at this
Vidal
point.
versus Elster, 602 U.S. 286.
Come on, get my health back up. Where's my
292 to
shield?
293.
Gone at this point, I imagine.
2024, explaining
Yeah,
the
looks like it.
difference. Cite as 607 U.
This is just the dissenting?
2026.
The dissenting is half the document.
Jackson, J. Dissenting. 1. Supreme Court of the United States. Underscore, underscore,
Oh, I'm
underscore,
killing it.
Underscore, underscore,
And by that I mean I'm being
underscore,
constantly killed.
Underscore, 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 underscore,
Underscore, uh-oh, it's doing this again.
Underscore, 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 number
Get used to it.
24 to 539, underscore, underscore, underscore,
Stay in there.
underscore, underscore,
Oh,
underscore,
one more to kill. Come on, bud. Let's do it.
Underscore, 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 underscore.
That's enough. That's genuinely enough. I'm good. I'm done.
Underscore,
I'm done here.
underscore,
Like I'm
Kaylee
just completely
Childs.
done here.
Petitioner v. Patty Salazar.
Holy
In
crap.
her official capacity as Executive Director of the Colorado Department of Regulatory
Oh my god, I can head
Agencies,
back. I can be
ETAL.
done with this for now.
On writ
I've
of
got what I
certiorari
need.
to the United States Court of Appeals for the 10th Circuit.
I just don't know if I'll get back without dying at this rate.
March 31st, 2026.
Okay,
Justice Jackson.
let's go.
Dissenting. T. Here is no right to practice medicine which is not subordinate to the police power of the states. Lambert
Hey,
versus
interesting.
Yell Lole, 272 U.S. 581, 596, 1926. This was true 100 years ago, and it should be true today. Many states have now chosen to exercise their police powers to ban conversion therapy, based on the medical profession's broad consensus that this medical treatment, which seeks to change a gay or transgender person's sexual orientation or gender
oriented.
identity,
Yeah.
is ineffective and harmful.
It is indeed harmful. Game,
This
you're getting really
case
dramatic
involves
again
the
with this theme
Colorado
music.
Legislature's policy
We're doing it, we're doing it, we're doing it.
licensed medical professionals from offering or providing conversion therapy to minors.
We're
in that
halfway through and
state.
I'm making pretty good progress.
Petitioner
Holy
Kaylee
cow.
Chiles is a licensed counselor who works in the state of Colorado. She does not dispute that conversion therapy can be harmful to minors in certain circumstances.
Game, I swear to God.
Nor does she contest
Oh,
that
it's right in front of me.
Colorado
I can
has a
see it.
significant interest in protecting minors from harm.
Please,
Child.
please, game, let me live.
Complains
me live.
nevertheless that, because the particular
Yes,
form
yes. You're kidding me.
conversion
Fire at the last
therapy she
second.
wants to offer clients utilizes
No,
only
I have
speech.
to
The
I have to
First
get there. Come on.
Amendment prevents Colorado from
Oh,
prohibiting
come
that
on,
treatment.
take me back.
But
Yes.
the power of government to regulate the professions
Oh my
is
God.
not lost whenever the
Oh,
practice
some of the best progress I've ever made in the game.
Two Chiles
Doing
v.
one of these.
Salazar. Jackson, J.
Okay, drop all this crap off.
Dissenting. A profession
I have enough for a
entails
diamond
speech.
pickaxe now too.
Low v. SEC
Holy
472 U.S.
cow.
181 228
What do I do now?
1985
Oh, I'm exhausted.
J. Concurring in result.
Okay, I've got a bunch of gold ingots.
And M. Edical professionals
I think I'm
do
going to put
not,
on a gold chest
generally
plate to see if I
speaking,
can get them
have
to
a
not
right to
aggro on
use
me
the
when they see me.
Constitution as a weapon, allowing them rigorously to control the content of reasonable conditions that a state imposes on licensed healthcare providers for the protection of its residents.
Okay, so there is precedent to this idea
National
that
Institute of Family and
it's
Life
not insane to
Advocates
ask
versus Becerra, 585
that medical people not be allowed to do things that literally just hurt patients.
785, 2018, Breyer, J. Dissenting, NIFLA. So, I respectfully dissent. Stated simply, the majority has failed to appreciate the crucial context in which Chiles's constitutional claims have arisen.
I see.
Chiles is not
Piglins.
speaking in the ether. She is providing therapy to minors as a licensed healthcare professional. The 10th Circuit was correct to observe that.
Alright, boys, are we angry about me or
Here
no?
is a long-established history of states regulating
Boys, stop going down there.
healthcare professions. 116 F. 4th 1178. 1206. 2024.
What's in there? Go.
And, until today, the First Amendment has not blocked their way. For good reason.
Huge.
Under
Okay,
our
we're trading.
pretense,
We're doing it. We're doing the thing.
bedrock First Amendment
I think I'd just like to
principles
make
have
sure
far
that I
less
can protect
salience
them
when the
and me
speakers
in the
are
meantime.
medical professionals and their treatment-related speech is being restricted
Oh my
incidentally
gosh,
to
we're
the
getting
state's
it. We're
regulation
trading.
of the provision of medical care. No one
Holy
directly
cow.
disputes that Colorado has the power to regulate
Yeah,
the
give me
medical
nicer
treatments that
items, guys.
state-licensed professionals
Give me
provide
goodies.
to patients. Nor is it asserted that, when doing so, a state always runs afoul of the Constitution. So, in
More
my
gold.
view,
Go for it.
it cannot also be the case that Colorado's decision to restrict a dangerous therapy modality that, incidentally, involves
Not really sure how
provider
useful that is to me.
speech is
I want Ender
presumptively
Eyes. As a
unconstitutional.
vendor.
In concluding
As a vendor.
otherwise,
I want
the court's
Ender Pearls is what I
opinion
want.
misreads our precedents,
What'd you just
is
give me?
unprincipled and unworkable,
Not particularly useful.
and will eventually prove untenable for
Fire
those
charge,
who
crime,
rely
obsidian, nether
upon
brick,
the
obsidian.
long-recognized responsibility of states to regulate the medical profession for the protection of public health. Cite as
Like if we discovered a medical practice is literally going to cause harm, then I would think that in alignment with the whole philosophy of
2026.
protecting the public interest, it would be allowed.
Jackson, J. Dissenting.
What did I just get? Soul speed. Fine, sure.
3.
Okay, I haven't gotten I haven't gotten any eyes.
To properly
I didn't get any eyes on that entire
evaluate the
program.
First Amendment claim at issue in this case, one must first understand the impetus for Colorado's regulation, what that law
You got anything else for me?
requires,
Or is that?
and the nature
Or we're
of
just
the
done here?
speech
We're
it
done here? Okay.
implicates.
It's a shame.
A. Conversion therapy is designed to convert a person's sexual orientation or gender
So
identity
from here, what can I
so that the
do?
person will
Oh
become
wow, this wide field of view
heterosexual or
really is
cisgender.
weird to me.
Generally speaking, conversion
Hi,
therapy
skeleton. I
began
just
as
want
an
you to know
attempt
I'm
to
very frustrated
cure
with you.
gay
Go
and
away.
transgender people of their non-conforming
Oh, it's because I have soul speed.
orientations or
I'm like running way
identities.
faster.
Brief
Jesus.
for American Psychological
scared me.
Association et al. As Amici Curiae 13.
Okay, so I didn't get any pearls from that.
Included aversive therapeutic
Now I guess I need to go
modalities.
try to get pearls on my own.
Those ranged from induct
guess.
ing nausea, vomiting, or paralysis in patients or subjecting them to severe
Jesus.
electric shocks to telling patients to snap an
Mhm.
elastic band
To non-conforming
on their
thoughts.
wrists in response
Yeah,
to
yeah.
non-conforming thoughts. Aversive therapies have now fallen out of fashion. Non-aversive treatments, primarily
Oh, OBS
form of
disconnected.
conversion therapy.
Let's see why.
All such therapies seek to encourage
OBS
patients
has now
to change
reconnected.
their
Okay.
behavior in an attempt to
What is the
change
issue, OBS?
their identity. Over the past few decades, however, the premise of conversion therapy, in whatever form, has been widely discredited within the medical and scientific community. Conversion
Looks like I am not getting little
is,
buddy to
at
turn
bottom,
back into
based on a view of
chill or
gender
whatever.
diversity that runs counter to scientific consensus. Substance Abuse and Mental Health Services Administration, SAMHSA, report
I don't understand.
570.
Okay,
That
whatever.
is, contrary to the core beliefs that undergird conversion therapy, a robust professional consensus now acknowledges that sexual orientations and gender identities range widely. And it no longer regards
Blackstone, hey, you know, at least that's kind of useful.
orientations or non-cisgender identities as non-conforming. For Chiles v. Salazar,
No, I guess I'll keep that on. It'll be useful.
Jackson, J. Dissenting. Because people's identities are simply a part
Okay,
of the normal spectrum
I'm not
of
really
human
sure what I can
diversity, ID,
as to what I can
at
do with what I've got for the time being.
535, the medical
I
community has
need
determined that
eyes.
efforts
I
to
need
change
eyes.
a
I need to start coming out during
part-time sexual
nighttime.
orientation or
Owning
gender
them outside and looking
identity will
for
necessarily be ineffective.
guys
The
to kill.
American Psychological Association,
Oh, being able to walk this fast.
APA,
Okay,
for
I'm
example,
changing my field of view
has
back to normal.
found no empirical evidence that providing any type of therapy in childhood can alter adult
Yeah, it's like I run
same-sex
faster
sexual
on sand than
orientation.
normal. That's crazy.
APA report 1 app 360. And NO research has been published in the peer-reviewed literature that demonstrates the efficacy of conversion therapy efforts with gender minority youth, nor any benefits of such
I mean, I don't see any
interventions to children and
anywhere.
their families. SAMHSA report 2 app 569.
You'd think they'd be spawning around by now, but
Not
they're not.
only is conversion therapy ineffective, former participants of conversion therapy report that it causes lasting psychological harm. Gay and transgender children who underwent non-aversive conversion therapy say they were taught to feel shame and self-hatred. See brief for conver. Shaun Therapy Survivor Network et al. As Amici Curiae 11-14. And survivors of conversion therapy continue to suffer from PTSD,
Oh, okay, a couple
anxiety,
of
and
boys to
suicidal
fight.
ideation.
Good stuff.
ID at 19 to 22. As one survivor put it, conversion therapy came close to killing me. ID at 17.1. One
Go to the end, they say. Yes, I know.
example.
I'm
An
trying.
amicus who
Okay, here we
received
go. First one to fight.
conversion therapy
Come
as
here.
a child, Matthew Shirka, was told that his sexual orientation was a disorder either rooted in childhood trauma or stemming from an overbearing mother or absent father. Brief for Matthew Shirka as Amicus Curiae 6.
Okay, keep doing this then.
In the course of this therapy, Matthew's therapist said that being gay was a mental
Dang
illness
it.
that could be cured and that, unless he was cured, he could never live a happy and fulfilled life.
What are you also
ID
angry about?
At 3.
Alright, where's the other one from a second ago?
Matthew's conversion therapists eventually hypothesized that his mother was the source of his sexual orientation and instructed him to avoid speaking with her. ID at 8.
Wait,
For 3 years.
what? This
he
is
had
a story where being gay was a mental illness to be cured, and that unless he was cured, he could never have a fulfilled life because this is evil. They eventually hypothesized that his mother was the source of his being gay. So avoid his mother? This just sounds like cult behavior where you're isolating a victim.
barely any contact with his mother. Ibid. The
Come on.
years of conversion therapy brought Matthew nothing but increased isolation from his
Yep.
family, worsening
all sounds
depression,
terrible.
and suicidal ideation.
A singular pearl. Let's
ID
go.
At 11.
1,000 more to go.
Thus, as Matthew's experience
Many more to go,
illustrates,
essentially.
the harm from conversion therapy extends to the patient's family.
Oh my god, I
See
guessed.
also brief for
I want you
parents of
dead.
conversion therapy
I genuinely
participants
want you
at
dead.
all as.
I want you extremely dead. Now
Cite
go for it,
as
asshole.
670.
No, we're playing this game right now.
Underscore, underscore,
okay, well, I guess that's not good.
underscore, 2026.
Leave me
Jackson,
alone.
J. Dissenting.
I will find you. I'll make a bow and arrow,
5.
and I will find you. I kind of have to make a bow and arrow to fight the dragon at the
The
end.
scientific literature confirms what anecdotal experiences
I need like
suggest.
2 or maybe 3 stacks
Conversion
of
therapy
arrows,
has
because I
harmed
suck.
Patients, particularly minors. The APA found that the reported negative social and emotional consequences of conversion therapy include self-reports of anger, anxiety, confusion, depression, grief, guilt,
Oh my goodness, what do I
hopelessness,
do?
deteriorated relationships with family, loss of social support,
Why do you all spawn on
loss
Soul
of
Sand so
faith,
easily?
poor self-image, social isolation, intimacy difficulties.
Why do y'all suck so much? Go
intrusive
away.
Imagery,
Yes, it's
suicidal
genuinely,
ideation, self-hatred,
hey, I'm happy to see the
and
document
sexual
in its writing
dysfunction.
is speaking on the science.
APA
It is
report,
indeed just torture,
one app,
produces many of the outcomes of
253
torture,
to
including like hopelessness.
254.
All
Even
the
for
terrible
those
things that come
study
with that.
participants who reported positive effects initially, many described experiencing the negative effects later. ID at 254.
What do I do here?
Moreover,
Seriously.
studies show that children often feel the effects of the shame and stigma from conversion therapy.
We are a little
even
over
more
halfway
vividly than
now,
adults
getting close to
due
2/3
their
of the way done, and I'm
increased
still not done with
emotional
this game.
vulnerability and less
I've been streaming for
developed
how long? I don't
capacity to
know.
cope effectively
2 hours. I suck at Minecraft.
with the harm of discrimination.
This is a pretty good start too.
Glass Gold Deckle, 1 app. 53 to 54, paragraph 50. Ultimately,
If I could get to one of those forests, I could find a higher incidence of Enderman. But similarly, I could just make a really flat area and have it spawn mobs for me.
First, conversion therapy stigmatizes the patient, telling them that their gender identity or sexual
Okay, I'll go this
orientation
way.
is something
We'll
to
see
be
where it
fixed,
goes.
rather than accepted. This reject tie-in can lead to shame and guilt, which in turn can cause long-term emotional distress. Second, conversion therapy sets patients up to fail by giving them an unattainable goal. Some patients have described that experience of failure as a significant cause of emotional and spiritual distress and negative self-image. ID at 63, paragraph 66.
I mean, I think it would not be wrong to say that conversion
B.
therapy materially contributes to people taking
In
their own lives.
2019,
Like it materially
Colorado
contributes to
joined
that outcome.
25 other states in banning the practice of conversion therapy for minors. Colorado's law, titled the Minor Conversion Therapy Law, MCTL, Amici Curiae 9 to 19.
I've officially strayed
describing the
too far
impact of
from my
conversion
spawn and must head
therapy
back.
on Amici's families,
I will be lost soon.
including the loss of loved ones to suicide.
Yep.
6 Chiles v.
The data shows it.
Salazar. Jackson, J. Dissenting. Prohibits licensed healthcare professionals from practicing conversion therapy with children. It defines conversion therapy as any practice or treatment that attempts or purports to
Leave me alone.
change an individual's sexual orientation or gender identity, including efforts to change behaviors or gender expressions or to eliminate or reduce sexual or aromantic attraction or feelings toward individuals of the same sex.
Okay.
Colorado Reverend
Still don't
Stat
see any
Section
more
12,
Endermen to fight.
245, 202,
I still don't know if I'm more likely to see them out
3.5,
in the
A,
nether or in the overworld at night. I don't know.
Point 2. Not all therapeutic discussions of sexuality and
Oh, my
gender
hands hurt.
identity are prohibited
Okay, so
by
I
the
cannot beat Minecraft in
MCTL.
3 hours, apparently.
The law allows practices or treatments that provide acceptance, support, and understanding for the facilitation of an individual's coping, social support, and identity exploration and development,
Leave me alone, you
including
jerks.
sexual orientation neutral interventions to prevent or address unlawful conduct or unsafe sexual practices, as long as the counseling does not seek to change sexual orientation.
I think I might just have
or
to start
gender identity.
searching really hard for
2.
guys
Assistance
to kill
a person
at nighttime
undergoing
in the
gender
game.
transition.
I mean, I could take the blaze spider I have
245,
and
202, 3.5b.
I could start in the direction I want to go, but
The Colorado
is a good choice.
legislature made these allowances after
Red
crediting
iron
witness
boots.
testimony and the professional consensus about conversion
Okay,
therapy.
let's just get my gear ready for the
namely,
next portion of the
that
run,
it is
essentially.
harmful, and that the preferred treatment for minors relating to their sexual orientation and gender identity is affirming care, i.e., medical care that helps minors focus on acceptance, support, coping, and identity exploration and development. Prohibit conversion therapy for a minor. Hearing on H.B. 2. The MCTL primarily applies to licensed healthcare professionals. Such professionals are already subject to a number of other restrictions on their professional practice. Most relevant here, under Colorado law, licensed therapists must provide therapy that is consistent with the standard of care, defined as the standards of practice generally recognized by state and national associations of practitioners in the field of the person's professional discipline. Colorado Reverend Stat Section 12, 245. 224, 1, G,
What else should I take with me? I don't really think the rest of this is that
Cite
useful.
as 607 U.S. ______ 2026. Jackson, J. Dissenting. 7. 19 to 1129
Oh, no
before
way.
the House Committee on Public Health Care and Hum. Serves, 2019 Leg. 72D General Session, Colorado, February 13, 2019. C. Chiles insists that, although she is a counselor licensed by Colorado, she has a constitutional right to flout Colorado's statute and the standard of care it incorporates if a client asks her to do so. Never mind that medical professionals, including counselors like Chiles, are generally bound to follow medical standards and state licensing requirements when they provide medical care to patients. Chiles wants to offer patients conversion therapy despite the MCTL and the medical consensus it reflects. So she has invoked the First Amendment, arguing that, because talk therapy is speech, no state can impose treatment standards like the MCTL on licensed talk therapists without first satisfying heightened scrutiny. As applied to Chiles, the MCTL
I guess
treats
I'll take
the
another war.
talk
I don't know what it'll be
therapy
useful
form of
for.
conversion therapy as a
Okay.
prohibited medical treatment.
Yeah, I guess I'll take Soul Sand. Why not?
But Chiles
Buckets
is
are
free
useful.
to express her opinion about the efficacy of
Redstone I may need later.
therapy or her disagreement with
Specifically for making a compass, probably right now,
Colorado's
actually.
conclusion that such therapy is harmful to me. Nors. Colorado's law does not target or prohibit the expression of such views by anyone in any form, including by licensed healthcare
I think I have everything I
providers in
realistically need to take
discussions
with me
patients
on
and
the
their
journey, so
families.
let's go.
all that
I'm
Colorado's
gonna leave that
law
bed just in case. I'm gonna
prescribes
grab
is
a different
provision
bed
of
from the
such
village
therapy
first,
to minors.
and then get rolling.
This means that, while Chiles can freely promote conversion therapy and vociferously decry the state's
Vociferously, what a
prohibition,
crazy word to
she
be using.
cannot practice that therapy without being subject to professional discipline under Colorado law. 2. I begin my analysis with a simple observation. Our First Amendment jurisprudence does not treat speech as existing. 8 Chiles v. Salazar. Jackson, J. Dissenting. In a vacuum. Instead, how the First Amendment applies to a state's power to regulate speech depends upon the context in which the regulation of speech occurs. See, e.g., Vidal v. Elster, 602 U.S. 286, 2024.
Yeah, I hear you.
Trademark context. Tinker v. Des Moines Independent Community School Dist.
I'm gonna head this way first.
393
Build up,
U.S.
and then go for it.
503, 1969. School context.
Whatever.
We have not mechanically held that the First Amendment protects all communicative content. Rather, we have evaluated First Amendment claims in a nuanced way, sensitive to both core principles and the specific circumstances under which the claim arises. See, e.g., Virginia B.D.
Why are they making weird noises? Because April Fools or what?
Citizens Consumer Council Incorporated.
Wow, this is an open area? There's gotta be a freaking Enderman somewhere, right?
748, 758.
Is that a mountain cow?
762 to 770, 1976. Considering First
Yeah, I hear
Amendment
that.
principles
Creeper,
in the
leave me
commercial
alone.
speech context.
Mountain pig. Why do you look like that?
In my view, then, it matters for First Amendment purposes that the MCTL restricts treatment-related speech.
I need a brighter screen. That's what I need. I need like an OLED super bright screen or something.
Regulatory scheme aimed at ensuring that providers
This seems like a pretty good area to go looking for Enderman, but
high-quality medical care to patients. In Part 2a, I explain that this way of conceptualizing the
really,
question
it broke
before
in the
us is
first
not
use.
novel. We have long understood that states
Oh
have
my
the
God.
power to
All right, well, I'm
regulate
heading this way
medical
for a while.
professionals. And our
until I
precedents
find another
demonstrate that
Enderman to
when
get an eye
healthcare
from.
provider's speech is incidentally restricted
This
as
is the
part of a
direction.
state
Okay,
law
well, I'm gonna
scheme
take my time.
regulating the provision of med-ical treatments, the heightened scrutiny we reflexively
Leave me alone, you
apply
asshole.
in other situations is not warranted. In Part 2b, I show that First Amendment principles are not offended when lesser scrutiny is applied to a state law regulating medical treatments in a manner that incidentally restricts a provider's professional medical speech. A case that we decided in 2018, NIFLA, shows us the way to determine the appropriate level of constitutional. Cite as 607
I find so often that the dissenting opinion in most Supreme Court opinion documents, the dissent, usually, I don't know why, in the ones I read at least, it always feels like the dissent is more rational, more reasonable, like more considerate, more like a reflection of normal people, more grounded, more down to earth.
We began by explaining that speech is not unprotected merely because it is uttered by professionals. ID at 767. See also ante at 10 to 11, 14. But, critically, we also acknowledge that the court has afforded less protection for professional speech
Oh, I
in
see.
two circumstances.
An Enderman to fight. Good
one
stuff.
of which occurs when a state regulates
Soul Sand. No, I don't want Soul Sand. I want
even though that
something to quickly build a
incidentally
thingy
involves
out of.
speech. NIFLA 585
Can I currently... Okay, wow, 2 Endermen. That's kind of huge for now.
C ante at 11. This acknowledgement was grounded in an already well-established principle. The First Amendment does not prevent restrictions directed at conduct from imposing incidental
Both of
burdens
them.
on speech.
Got both of them right now.
Sorel v. IMS Health
Please give me an eye. The
564
first one broke immediately.
U.S. 552, 567,
Nothing. Come on,
2011.
where's the other one?
To further explain the contours of this presumptively permissible speech restriction, NIFLA cited Planned Parenthood of Southeastern PA v.
Nothing.
Casey,
God dang it.
505 U.S. 833,
I'm not sure what the plan is then.
1992.
Just get food for the
In
next...
Casey,
until
the court assessed
nighttime, essentially.
and asserted First Amendment right of a physician not to provide information about the risks of abortion and childbirth
What is
in
this?
a manner mandated by the state. ID at 884, joint opinion of O'Connor, Kennedy, and Souter, J.J. More specifically, Casey involved a challenge to a Pennsylvania law requiring that...
Yeah, I've got to read this. This is really interesting. The First Amendment does not prevent restrictions directed at conduct from imposing incidental burdens on speech. To further explain the contours of this presumptively permissible speech restriction, NIFLA cited Planned Parenthood of Southeast Pennsylvania versus Casey. In Casey, the court assessed an asserted First Amendment right of a physician not to provide information about the risks of abortion and childbirth in a manner mandated by the state. Well, let me read that again. Physicians were asserting their First Amendment right to not provide information about the risks of abortion and childbirth in a manner mandated by the state. Oh yeah, so you cannot compel speech. Cannot compel the risks of abortion, cannot compel the risks of childbirth. It's because people still die in childbirth a fair bit. Interesting.
Doctor give a woman certain information as part of obtain ing her consent to an abortion. Ibid. Point 3 we held that Pennsylvania's informed consent mandate did not violate the First Amendment. To be sure, the physician's First Amendment rights not to speak
Now let me read this again. Again, so more specifically, Casey involved a challenge to a Pennsylvania law requiring that a doctor give a woman certain information as part of obtaining her consent to an abortion. So it was a law that said doctors have to tell women about the risks of an abortion before having them do one. We held that Pennsylvania's informed consent mandate did not violate the First Amendment. To be sure, the physician's First Amendment rights not to speak were implicated, but we emphasize that those rights were implicated only as part of the practice of medicine, subject to reasonable licensing and regulation by the state. Thus, there was no constitutional infirmity in the requirement that the physician provide information. So they said, yes, you're allowed to compel speech of doctors to warn patients about the risks of abortion.
Implicated by Pennsylvania's law.
And technically childbirth itself too, but
we emphasized that those rights were implicated only as part of the practice of medicine.
Oh, a lava pool that might have been very useful earlier, but whatever.
Regulation by the state. Ibid. Emphasis added.
Oh, another abandoned portal.
Thus, there was no constitutional.
Yep, we're stuck on a part that we've been stuck on before, which is the amount of time it takes to get frickin' Eyes of Ender.
The flip side of the one Chiles brings here. While the doctors in Casey complained that Pennsylvania was forcing them to speak when they did not
Maybe
want
I just
to,
suck at this game.
Chiles asserts that Colorado is preventing her from saying what she wants to say. 10 Chiles v. Salazar.
Okay, there's another 9 blocks of
Jackson, J.
bricks of
dissenting.
We'll just see.
Infirmity in the requirement that the physician
Neither of those are
provide
useful
the
to me.
information
Neither of those are useful to
mandated
me.
by the
The
state.
only thing useful to me was maybe.
Ibid. In NIFLA,
Maybe
we
this block was useful
reaffirmed
at some
the
point.
principle from Casey that the First
Not at this moment,
Amendment
though,
inquiry
unfortunately.
requires consideration of whether the regulated speech was made during the provision of medical care.
There's a lot of
NIFLA
chickens over.
involved a
You know what? I'm killing the
challenge to a
chickens.
California law that required certain crisis pregnancy centers to post
The more
notices
feathers I
in
get,
their
the better for
waiting
later in the
rooms
game.
informing low-income patients that
I
California
need something to do
paid
while
for
it's still daytime.
qualifying abortions. 585 U.S.
Why are there
at
30 chickens right here?
762 to 763. We asked whether, on the one hand, this law was regulating the clinic's speech qua speech, or whether, on the other, the notice requirement was actually regulating the clinic's professional conduct and only incidentally restricting speech. If the latter, the NIFLA court explained, California's notice requirement would fit into the category
Wow, I'm at level
of
14
cases
right
that
now. I haven't died in a
Casey
while.
illustrated, namely, those in which this court has upheld regulations of professional conduct that incidentally burden speech. 585 U.S. at 769. Relying in part on Casey's analytical framework, the NIFLA court held that
If I could just
California's
get
law
2
regulated
ender
speech
pearls, I
as
think that would
speech.
make a difference for me.
585 U.S. at
I think I could get pretty
770.
close to the
We
end portal.
explained this
very
conclusion
least.
by contrasting the Pennsylvania regulation at issue in CA say, while the notice requirement in Casey restricted doctor speech, it did so only as part of the practice of medicine. 585
So it's okay to restrict
U.S.
speech
at
if it's only in one
770.
context, specifically a professional
The
context.
notice requirement at issue in NIFLA, by contrast,
So to some
was
degree,
not an
the dissent is
informed
rightfully pointing
consent
out that
requirement or
the
any other
Supreme Court's
regulation
not
of
being exactly
professional
consistent here
conduct.
with their reasoning.
In
There's
fact,
obviously some evidence.
California's notice was not tied to a procedure at all. It applied to all interactions between a covered facility and its clients, regardless of whether a medical procedure was ever
Armadillo. I do not
sought,
need an armadillo
offered,
something.
or performed.
I do not need infinite wool.
Faces
I do not need a lot
added.
of leather. Leather. There
So,
we
we
go. Be gone, leather.
reasoned, unlike Pennsylvania's informed consent requirement in Casey, California's notice mandate warranted heightened scrutiny because it late speech as speech. 585 U.S. at 770. Cite as 607 U.S. _____ 2026. Jackson, J. Dissenting. 11. The takeaway from NIFLA is that Casey applied a lower level of scrutiny because the law in Casey restricted speech uttered in the course of, and as a part of, providing professional medical care.
Is this the village again? Am I back at the village?
The
Or is
notice
this is a different
requirement
village,
in
isn't
NIFLA
it?
was not tied to a procedure
Well,
at
it'd be
all,
nice to get a bunch of
and
food
was
here.
therefore meaningfully different. That law restricted speech as speech.
I also feel like I see Enderman spawn close to villages. Is that crazy?
US at
Feels a little crazy, but I don't think I'm
770.
crazy.
Thus, the key distinction, as the NIFLA
Egg.
court
I guess
saw
I could
it,
keep the eggs
was
for
whether the challenged
farm later,
law
but
was a
I have so many
regulation
feathers
of
already.
speech as such or a regulation of professional conduct that incidentally burden speech. ID
those out of my way.
at 769. 2.
Okay, we're getting really deep into the document still.
Given all this, one might think today's majority would make more of an effort to explain why the MCTL does not likewise qualify as a regulation of professional conduct that incidentally burden speech. C. Ante, at 1417. Such an inquiry would entail evaluating whether the MCTL's restriction on Chiles's therapy only incidentally restricts Chiles's speech by virtue of the fact that the medical care she provides is delivered orally. It would also require
as if the speech is action by virtue of that being the mechanism by which the care is delivered. That's crazy nuanced, and you're really reaching, but go for it. Go for it, why not?
One that, but for Colorado's law, a licensed counselor like Chiles might offer to minors. In my view, it is obvious that the MCTL is regulating professional conduct insofar as it prohibits providing a particular therapy. The aim of the statute is not suppressing speech. Indeed, Chiles's claim that her, otherwise protected speech is being swept up by Colorado's, otherwise
fisherman,
valid, treatment prohibition proves that very point. This set of circumstances seems to fit NIFLA's idea of permissibly state
oh my god, a day-night cycle is taking so long in this game right now. Holy cow.
Burden speech to a T.
This is a pretty open and flat area, it looks like.
Suggests otherwise with the opinion it hands down today. Ante, at 14 to 17. The majority. 12 Chiles v. Salazar.
Okay, hey bail.
Jackson.
Many more.
J. Dissenting.
Uh-oh. I made a slight mistake.
Does this primarily
I don't need more of
by
these.
eschewing
They're not
serious
necessarily.
engagement with the interaction between NIFLA and Casey?
I don't need another wart. I don't need
Its
soul sand.
workaround
Let's get these things
seems
out of my
to
way.
be,
They're not
the
helping me.
First Amendment applies full bore here because Chiles's speech is being impacted. After all, she is a talk
yeah,
therapy
those are gone.
provider.
Nope, they're still in the way.
Ante,
Okay.
at 12 to 17. But when NIFLA's teachings are properly understood, this comeback is no unswerve. Yes, Chiles happens to be talking when she's provid ing therapy to patients, but the MCTL regulates the provision
I need a
of
dry
medical
gas. Oh my
treatments
goodness,
by
I have too much
licensed
crap on me.
medical
I'm losing it.
professionals, which states
I don't
fully
need these chest
empowered
plates.
to
I don't need...
that Chiles's kind of medical care involves talk therapy.
soul sand. I don't need
in
nether
NIFLA's
warts. I
words,
probably don't need redstone. I can go get redstone pretty much anywhere in this game.
585 U.S. at 769.
Okay.
I am the first to
Back
admit
to making
that,
bread.
as
Okay.
applied to talk therapists like Chiles, the MCTL restricts speech. I do not argue that this law really just limits Chiles's professional conduct. See Ante, at 12 to 13, 16, characterizing Colorado's argument. Similarly, I
There's
do
so
not
much
maintain
bread.
that, because this law primar highly regulates talk therapists' professional
I really need to
conduct,
practice
should
just
not
the
be
nether part of this
conceived
game
as
so I
a
can get through it
speech
faster.
restriction. See Ante,
Okay.
at 16.
We are looking for
I agree
Enderman to
with
kill.
the majority that, in cases like Cohen versus California, 403 U.S. 15, 1971, we firmly rejected a state's attempt to suppress free speech by calling the restricted expression conduct. Ante, at 16. But, here, the observation that the MCTL indeed restricts Chiles's speech, not reformulat as conduct, just raises the question that this case presents, whether the MCTL is restricting Chiles's speech, incidentally, to its regulation of medical professionals' treatment-related conduct, such that the law warrants less scrutiny under the First
I have
Amendment
fought so
than
many
a law
Endermen
that
and still
restricts
not
her speech as
gotten what I need
speech.
to.
NIFLA, 585 U.S. at 769,
I fought those two back to back and I still couldn't.
The majority's
Get an eye.
failure to acknowledge that this is the AC tool issue here, not just whether Chiles's speech or conduct is being restricted, but what the state is doing, i.g. knows what has always been true under our precedents. The real lesson of NIFLA's discussion of Casey is this: when cite as 607
Is there not like an accessibility feature in this game that lets me zoom?
2026. Jackson, J. Dissenting. 13. A healthcare professional's speech is not being targeted as speech because it conveys an idea, but is instead incidentally restricted due to a state's otherwise legitimate regulation of the medical treatments.
I see an Enderman. Okay, let's see if I can trigger it from all the way over there.
Scrutiny is not warranted. 585 U.S. at 769 to 770. Casey,
come on, game. Don't screw this up.
U.S. at 884. Joint opinion of O'Connor, Kennedy, and Souter, J.J. 3. NIFLA's focus on a state's regulation of medical
I'm not close enough to him.
also undermines the position the United States
I can't believe it. I'm actually not close enough to that Enderman to make him attack me.
The United States,
and now he's
this
gone.
case as
Okay, what?
Curiae, insists in ES
So if the game didn't know computers that were better would exist one day.
That states can regulate professional conduct while incidentally restricting speech.
Where'd he go?
It was blessing only two circumstances. One, where the speech that is being restricted is inextricably tied
He's just gone,
to the
isn't he?
act of the speaker. So,
This game,
speech-only therapists are never included.
I don't know how
Or
real
two,
speedrunners do this.
where speech is being regulated
Whoa!
in a manner entirely
I guess that would've
unrelated
sucked.
to its content. Brief for United States as Amicus Curiae 17 to 21.
What's an armadillo
See
right there?
ante at 11, 15 to 16.
Dang it!
But under NIFLA's reasoning,
I'm looking for the color purple.
at least not
anything.
logically.
Tiny
With
purple
respect
eyes.
to the first category, the United States mistakenly swaps integral, i.e., whether the restricted speech is bound up with the regulated conduct, for incidental. But these are two completely different concepts.
Holy
Point 4
crap, what is this hole in the ground?
For under the reading the United States advocates, the line between permissible and impermissible state regulation seems to turn on the relationship.
Yeah, I know I'm getting
between the
old because I am
restricted
tired
speech
just from
and
3 hours of
physical
this.
act of the speaker. CTR of Oral Arg 35 to 36. So, the argument goes, the First Amendment allows state regulation if the speech restriction is incidental to a physical act of the healthcare provider,
Leave me
but
alone.
prohibits it if there is no physical act for the speech to be incidental to because the provider treats patients solely with speech. CID at 35 T. His court hasn't drawn a particularly clear line about when speech
The hell
is
kind of
close
noise was
enough to
that?
conduct to be viewed as incidental.
Why do I
But
feel like the
here,
nights are so fast in this game, but
this
then
is an
the
easy case because
days take forever?
14 Chiles v. Salazar. Jackson, J. Dissenting. NIFLA's focus on the incidental nature of the challenged speech restriction, the state's objective is the actual fulcrum. We ask whether, on the one hand, the state's law is restricting the provider's speech incidentally, meaning in the course of the state's pursuit of its primary objective of regulating the provision of medical care, or whether, on the other, the state's law is restricting her speech as speech, primarily to suppress its message or expressive content.
Whoa.
585 U.S. at 769 to 770.
This hurts my eyes. I need like
The
a bigger
appropriate
screen
scrutiny
somehow.
level
I already have a very
logicality
large screen for this
follows.
game.
Incidentally, restricting speech needs less scrutiny because we view the state as generally regulating the provision of medical care, while restricting speech as speech receives heightened scrutiny because the state is aiming at professional speech qua speech. The second, speech incident to conduct, category the United States advances, whether the restriction on speech is unrelated to its
That's a big
content,
mountain.
is also fatally flawed. It ignores what NIFLA plainly recognizes, that states can regulate the medical treatments healthcare professionals provide to patients without running afoul of the First Amendment, even if the regulation applies to and restricts speech based on its content. 585 U.S. at 769 to 770. In other words, what mattered to NIFLA's analysis was not that the regulation was
You want to get to the
content-based,
top of this
but
mountain?
instead that the speech was being restricted.
Then maybe just hang here
incidentally.
moving forward because
There is no conduct
it'll give me like a high
ID
contrast place
at
to look for
33,
Enderman from.
emphasizing that, because Chiles is a talk therapist, here's no separate non-speech conduct being regulated here. See also brief for United States as amicus curiae 24-26, noting that regulations of the mental health profession are less
Oh
likely
my
to
God,
qualify
where
as
am I in the
incidental
game?
burdens
What?
on speech. Because much mental
How did
health
this even
treatment
happen?
is conducted using only speech.
It's like the Badlands or
This
something.
logic
Is that
rests
a
upon the integral
underwater
nature of the speech to the conduct that
unfinished
is being
portal?
regulated.
When did that
But
even
that
become
is
an
different
option?
from, and says nothing about, whether the speech is being regulated incidentally, which is the
Sure,
line that
perish,
NIFLA
jerk.
draws. See National Institute of Family and Life Advocates versus Becerra, 585
Can...
U.S. 755,
Oh my God. This is
769
terrifying.
to 770, 2018. Cite as 607 U.S. underscore underscore
Right.
underscore
Alright,
underscore
water, let's get it.
2026.
Okay, is there a...
Jackson, J. Dissenting. 15. So it is here. Talk therapy is a medical treatment. 116 F. 4th at 1206, 1208 to 1210.
None of these things are particularly useful to me. I'm out.
So, why wouldn't such speech-based medical
God dang
treatments
it.
be subject to reasonable state
What?
regulation
How am I even
like
getting
any
up there?
other kind of medical care?
What a
The
ridiculous...
United
What is
States
Minecraft
and the
generated? Like,
majority
look at
just
this.
insist that a law that undertakes to regulate speech-based medical treatments
Holy
is
crap.
presumptively unconstitutional.
I need to find like a
because
desert or
the
something.
treatment is being
Something
administered
equivalent
solely
to that.
through speech. But that reasoning is maddeningly circular, and it is based
I accidentally
on
hit Control F, I think.
happenstance, not logic. Even more,
What are you doing? Get back to reading.
states and the majority just insist
Why
that
has
a
it...
law that undertakes to
Why are these
regulate
comments? Are these
speech-based
changes from the
medical
previous
treatments is
version?
presumptively unconstitutional because the treatment is being administered solely through speech. But that reasoning is maddeningly circular, and it is based on happenstance, not logic. Even more important, it is not the rationale upon which NIFLA's analysis relies. To the contrary, with its description of Casey, NIFLA recognizes precisely the opposite. A state can regulate professionals' treatment-related conduct even if doing so impacts treatment-related speech. Again, what distinguished NIFLA from Casey was the fact that Pennsylvania's speech-related mandate was aimed at regulating the provision of medical treatments to patients. The fact that the
I need to find a
particular
flat,
medical
open
treatment
area
at
that
issue
can spawn
in
a bunch of
Casey
Endermen.
involved a physical, instead of a verbal, act was of no moment. NIFLA 585 U.S. at 769 to 770.
The issue is I'm probably walking in the wrong direction right now.
Of NIFLA, the United States
Like I'm walking away from where the end portal probably actually is, and I just don't know.
Appears to endorse in part. C ante at 16 to 17.
This isn't the pirate ship from the beginning of the game, is it? I don't think a pirate ship can even have interpearls in it.
For purposes of the state's regulation of harmful professional conduct,
what is this over
treatments
here?
administered through words versus treatments administered through
Just
acts
a piece of
are
sand.
not meaningfully different. Point 5.
No, it looks weird. What is this?
The majority appears to adopt a theory of the speech incident to conduct doctrine that is analytically
The heck is this supposed to be?
But ultimately narrower.
I don't like water
The
zombies.
recitation adopted by the United States. Ante at 16 to 17. But, just like the United States, the majority fails to account for NIFLA's conceptualization of the doctrine as turning on the state's objectives. Indeed, the majority's analysis offers no cohesive narrative to explain either why this exception to heightened scrutiny exists or how, like all exceptions, it operates to consistently affect a balance of the public's interests. Here,
I'm pretty sure that's a portal I've seen before.
That medical standards secure.
Man, these portals are everywhere now. They make it faster to beat the game.
Chiles v. Salazar.
Oh gosh.
Jackson J.
Been streaming for 3 hours now. Exciting.
By contrast, NIFLA's actual line marks a real, constitutionally relevant distinction. Restrictions of speech that occur when a state undertakes to regulate the treatments
no, I've been here before, haven't I?
Provide to patients
yes.
are merely incidental. Great. They are materially different from speech restrictions that are not tied to a medical procedure at all. 585 U.S. at 769 to 770. Cf. Black's Law Dictionary 686, 5th edition 1979, defining incidental as d. depending upon or ap pertaining to something else as primary, such as something incidental to the main purpose. The latter warrants strict scrutiny since the state is regulating speech as speech, while in the former case, where the state is merely restricting speech due to its regulation of medical treatments, heightened scrutiny is not needed. 585 U.S. at 770. The speech incident to conduct.
Right, this is like a fairly open area. I think I'm just going to have to deal with running around this area until I find it Enderman, essentially.
To regulate the practice of medicine for the protection of its residents while also ensuring that speech is not being targeted.
Okay then. Right,
as we explained in NIFLA, that doctrine recognizes that the treatments provided by licensed medical professionals
build a house, essentially,
can be prohibited even if, by doing so, the state incidentally restricts those providers' speech. ID at 769
like a house out of wood? I almost never do that.
770.
I'll do it.
This is constitutionally permissible precisely because the restricted speech is not being regulated as speech, i.e., based on or due to its message or expressive content. Rather, the speech restriction is a mere byproduct of the state's healthcare regulation. So, at the end of the day, I think what we have here is what Casey involved and NIFLA did not, a state restricting a medical provider's speech only as part of its regulation of the provision of medical treatments to individual patients. See NIFLA 585 U.S. at 769 to 770, Casey 505 U.S. at 884, joint opinion of O'Connor, Kennedy, and Souter, J.J. And It is precisely because the MCTL is restricting Chiles's speech only as part of her practice of medicine that the cite as 607 U.S. ______ 2026. Jackson, J. Dissenting. 17. First Amendment is not particularly bothered despite the impact on her speech. Casey, 505 U.S. at 884, same. AC accordingly, talk therapists like Chiles, just like any other healthcare provider seeking to treat patients, can presumptively be subject, ed. to reasonable licensing and regulation by the state. Ibid. B.
Oh, place a bed.
The
Let's see
conclusion
she
that
bed.
a
There you
state
go.
can
Cool.
regulate the provision of medical care even if, in so doing, it incidentally restricts the speech of
Look at
some
these weird
providers,
eggs that I have.
fully comports with the First Amendment's animating principles. These principles include the
I do
well-settled
have like literally
notion
infinite
that
food at this
context
point. Brown.
matters
What
when
do you mean brown
evaluating
egg?
First
What does that do
Amendment
for me?
challenges to state regula tie-in.
Okay,
See
I guess I'll make a
Virginia
pig pen real
BD
quick for
of
fun.
Pharmacy,
Not a pig pen, but a chicken pen. If I can make one.
425 U.S. at 762 to 768, analyzing the First Amendment protections due speech in the commercial context, cf. Central Hudson Gas and Elec. Court v. Public Serv. Comment of N.Y. 447 U.S. 557, 564, N. 6, 1980, explaining how the context and characteristics of commercial speech justify less scrutiny. The context that frames today's debate is the kind of speech that
I
is
hear
at issue
a pillager.
here, what I am calling, as shorthand,
Yeah, leave me alone,
professional
jerks.
medical speech.
I'm not even a. What do
This
you
is
call
the
it? I'm not
only
even a
type of
freaking.
speech the MCTL restricts. 1.
Leave me alone.
Properly
I do not
defined,
want your bullshit.
professional medical speech is a NAR row category. It is not all speech uttered by profession ALS. NIFLA,
Go away, jerks.
585 U.S. at 767.
Oh, good, and I don't have to do
Rather,
this stupid.
it is speech by healthcare
Psych quest that it
professionals
grants or
made as
whatever.
part of their provision of medical care to patients. To be even more specific, professional medical speech occurs when a medical professional speaks to a client, 1.
No
in the
chickens. None.
context
Absolutely
of the
zero.
professional part-time
Wonderful.
relationship, 2. on matters within the provider's
Okay,
professional
now I'd like to build
expertise as
an
defined
extremely
by the
high
medical community, 3. for the
tower
purpose
that I
of
can climb up and
providing
down
medical
with
care.
water.
CC hopped.
One
18
bucket of
Chiles v.
this.
Salazar.
One of those. Couple of
Jackson,
these.
J. Dissenting. Professional speech, 125 Yale L. J. 1238, 1247 to 1248, 2016, are post informed consent to abortion, a First Amendment analysis of compelled physician speech, 2007 U. Ill. L. Rev 939, 947, D. Halberstam, Commercial Speech, Professional Speech, and the Constitutional Status of Social Institutions, 147 U. Pa. L. Rev 771, 834, 1999. First, professional medical speech is speech uttered within the bounds of the professional-patient relationship. See, e.g., Haupt, 125 Yale L. J. at 1254 to 1255. That relationship imposes certain duties and restrictions on the medical professional. For example, medical providers are bound by the twin duties of beneficence, the obligation to act for the benefit of the patient, and non-maleficence, the obligation not to harm the patient. B. Varkey, Principles of Clinical Ethics and Their Application to Practice, 2020 Med. Principles and Prac. 17, 18.6 second, professional medical speech is speech within the healthcare provider's area of expertise as a member of the medical community. Haupt, 125 Yale L.J., at 1248 to 1251. Within the professional-patient relationship, the professional has knowledge that the patient does not have, include ing knowledge of which medical treatments are appropriate and how to administer them. The patient comes to the provider to access that expertise, which is informed by, and constrained by, what the medical community knows.
Hey.
CID, at 1243.
Right, I might have not chosen
Finally,
the best
and
area
most
for this.
importantly, professional medical speech is made for the purpose of providing the patient with.
I see 100, man.
6.
Okay,
This means,
get to work then.
of course, that a provider is
Oh,
not
I think it's already
employing
gone.
professional
That took no
medical
time at all.
speech when speaking outside of the professional-patient relationship. The provider who gives a speech touting the benefits of conversion therapy, or writes a paper criticizing
Oh, I
those
see
who do
him.
not
Let's get
practice
it.
conversion therapy, or even expresses to a patient her general, non-treatment related, views about conversion therapy does not have the due ties that arise in the context of the professional-patient relationship and, accordingly, is not engaging in professional
Let's do
medical
it.
speech. Cite as
Come get me.
607 U.
No, he'll just drop a block. Dang it, because he has a block. Place it.
2026. Jackson,
That's an I.
J. Dissenting.
A singular I.
19. Medical care. CID at 1255.
One is not enough. I need two.
This speech is a tool
I need at least two
employed
to head towards the end.
patients.
I don't think
In
I'm winning
this
though. Even
sense,
though I made great progress and great
professional
pacing this whole
medical
time,
speech
I don't think I'm
facilitates
making
the
it. It
professional's
seems.
goal of providing the patient with the treatment, procedure, or healthcare that is within her expertise and that forms the basis of the professional-patient
Oh, there's like a few too many enemies right here, aren't there?
2.
Does the game have an
Keeping
effect
in
where if
mind
you build a
these
tower, it
characteristics
attracts
of
enemies to
professional
you?
medical speech,
I'd believe
consider
it, but
the First
I
Amendment
just didn't know
principles that
until now.
serve as guideposts for determining the level of scrutiny that a government
Leave me
restriction
alone.
of such speech deserves. First, and most
Let's get that thrown in
fundamentally,
there.
is preservation of the marketplace of ideas. See Abrams versus United States, 250 U.S. 616, 630, 1919, Holmes, J. Dissenting, Meyer v. Grant, 486 U.S.
Feel like I could be going up this faster.
421, 1988.
Whoa, okay.
Indeed,
So maybe I need to be
the
more
whole
careful about
project
that.
of the First Amendment stemmed from the founders' desire to protect the critically important goal of having a well-functioning sphere of expression in which citizens have access to information from many sources. Moody v. NetChoice,
Let me Google
LLC,
how to do this.
603 U.S. 707, 732, 2024. Within the marketplace of ideas, speech that is expressive of the speaker's thoughts and views is, generally speaking, highly valued. See Leathers vs. Medlock, 499 U.S. 439, 447, 1991, Ashcroft. 5. American Civil Liberties Union, 535 U.S. 564,
So, but I can
573 to 574.
just do that with my... Okay, sure.
2002. But professional medical speech does not intersect with the marketplace of ideas.
Okay, I had not thought to do this before.
And the context of medical practice. We insist upon competence, not debate. Post 2007 U. ILL Rev at 950.
I mean, this is a relatively flat area.
Medical providers speaking within the boundaries of providing patient care can express themselves is limited because their interactions with patients are constrained by their well-established due ties to those
I'm also just tired.
And the requirement that they meet the standard of care. Moreover, given these limits, professional medical speech does not necessarily involve the 20 Chiles v. Salazar. Jackson, J. Dissenting. Expression of ideas or messages, so it does not provide significant value to the general marketplace. C. Dunn and Bradstreet Incorporated v. Greenmoss Builders Incorporated, for 72 U.S. 749. 758 to 759, 1985.
Okay, let's take a look at the actual document and see how much is truly left. How much of it is just stuff at the bottom. No, this keeps going for sure. Oh, it goes until the very end. Okay, I guess I have
plurality opinion.
Another hour or so.
That's not to say that there isn't a robust marketplace of ideas within the medical community. Medical professionals contribute to that particular.
I am tempted to just start running around and looking for
giving speeches, and pushing the bounds of the community's knowledge through experimentation. And, indeed, the standard of care for a medical treatment can be greatly influenced and changed by virtue of such speech. It is there that truth competes for accept.
I really only need to take this bread at this point.
Market. Abrams, 250 U.S.
Yeah, there are monsters nearby, you know? I feel like I've noticed that.
J. Descent ing. But that marketplace exists outside the confines of the professional-patient relationship. C. Haupt, 125 Yale L.
Come on, let me go to sleep.
At 12:43 to 12:44,
I don't want to do this in the middle of the night.
Discussing the epistemic
or maybe I do.
Marketplace among medical professionals.
I don't even.
Within the confines of the professional-patient relationship, treatment-related truths are a given. They are set by licensing and malpractice standards, and it is not uncommon that such regulation incidentally restricts provider speech. Moreover, regulation of the practice of medicine is pervasively and unavoidably viewpoint-based.
We gotta be joking at this point.
The majority and the concurrence both resist this. They relentlessly
every time I throw one, it breaks. What are the chances of that?
Discrimination by banning conversion therapy but permitting affirming care. Anti at 13 to 14, majority opinion. Anti at 1 to 2, Kagan, J, concurring. But context makes that point ring hollow. When a state establishes a standard of care, or punishes a doctor for providing care outside of that standard,
they all suck, and this game sucks too. Why have my chances
on the basis of viewpoint?
For Ender has been so bad recently.
Can permissibly prohibit the administration of specific drugs for particular medical uses, but not for others.
Seriously, why has it been so bad?
United States versus Scrimeti. Cite as 607 U.
What is Scrimeti? Scrimeti's the one that made
_____2026.
made it so not recognizing trans people as people is legitimate, right? or not recognizing trans people as a category that can be
21.
discriminated against.
605 U.S. 495, 516.
Game, I am so sick of this bull.
2025.7 So, 2. May it prohibit a doctor from encouraging a patient to commit suicide, CTR, of oral ARG 43 to 45, or a dietitian from telling an anorexic patient to eat less, CID, at 22 to 23.
So too may it prohibit a doctor.
Likewise, no one
Oh
would
my
bat
God,
an eye
I'm
if
about to
a
die
state
from this.
required its doctors to discourage, but not encourage, smoking
Tobacco.
Even though
No one would
these
bat an eye if a
kinds of
state required its doctor
regulations are
to
inherently
discourage,
viewpoint-based,
but not encourage,
in the context
smoking
of medical
tobacco.
care, a state can certainly require the medical professionals it licenses to stand on one side of an issue.
Yeah.
See Collins versus Texas.
Right, this is a really rational explanation.
S. 288, 297 to 298, 1912, recognizing the right of the state to adopt a policy even upon medical matters concerning which
Okay,
there is
let's check
difference
this
of
out.
opinion.
This is very rational suddenly. When a state establishes a standard of care or punishes a doctor for providing care outside of that standard, it necessarily limits what medical professionals can say and do on the basis of viewpoint. A state can permissibly prohibit the administration of specific drugs for particular medical uses, but not for others. That was in United States versus Scrimetti. Wow, they're referencing that one because it allows children access to, because I read it on the stream, it allows some children gender affirming care and not others, specifically if they're trans. So too may it prohibit a doctor from encouraging a patient to commit suicide, or a dietitian from telling an anorexic patient to eat less. Likewise, no one would bat an eye if a state required its doctors to discourage, but not encourage, smoking tobacco. Even though these kinds of regulations are inherently viewpoint-based in the context of medical care, a state can certainly require the medical professionals it licenses to stand on one side of an issue. And using Scrimetti against them is a pretty interesting approach here from this justice. You could kind of use Scrimetti like that. I hadn't thought of it. Interesting.
Jackson, J.
It's like fuck around, find out. Like,
21.
you guys decided this.
605 U.S. 495, 516, 2025.7 So, 2. May it prohibit a doctor from encouraging
I'm about to Google,
a
how do I
patient to
find
commit
Enderman more
suicide,
quickly?
CTR, of oral
Why am I
ARG
so bad at finding them in
43 to
general?
45, or a dietitian from telling an anorexic patient to eat
I'm Googling
less,
that.
CID, at 22 to 23. Likewise, no one would bat an eye if a state required its doctors to discourage, but not encourage, smoking tobacco. Even though these kinds of regulations are inherently viewpoint-based, in the context of medical care, a state can certainly require the medical professionals it licenses to stand on one side of an issue. See Collins versus Texas, 223 U.S. 288, 297
That's funny, I just Googled the thing I built.
298, 1912, recognizing the right of the state to adopt a policy even upon medical matters concerning which there is difference of opinion and dispute. Though these proscriptions certainly promote a viewpoint, in this context, that alone does not suffice to establish a presumptive First Amendment violation. Instead, under the speech incident, to conduct doctrine, the challenged laws must also operate as speech suppression
You make a bunch
tools
of boats and
designed to
hope that
vanquish
enemies
free
spawn around
express
your pillar?
But, here, Colorado's clear aim is
Can you put
enforcement
Enderman in
of the
boats?
standard of care that is indisputably applicable to the state's licensed healthcare professionals. Taking a position as to how those providers should handle a medical issue is the very essence of standard setting. Once again, this kind of viewpoint-based regulation ensures competence, not debate. Post 2007 U.L.L. Rev. at 950. My colleagues' contrary conclusions are puzzling, for a standards-based healthcare scheme cannot function unless its regulators are permitted to choose sides. Point 8.
Which villagers give pearls?
7. Of course, when the state discriminates on the basis of sex and transgender status, with respect to the administration of specific drugs, that discrimination implicates the Equal Protection
Cleric.
Clause and requires heightened scrutiny
We're doing that
for
then.
purposes of the 14th Amendment.
Guess I should have tried that earlier, huh?
See Scrimetti, 605 U.S. at 579.
There's a couple of villages nearby.
Sotomayor, J. Dissenting. 8. Faulting Colorado for legislating based on its view that conversion therapy is harmful for minors and that
Okay, heading back to a
affirming care
village
is
looking
the
for a
better.
cleric. Trade them some basic stuff and
22
go from there.
Chiles v. Salazar.
Leave me
Jackson,
alone.
J. Dissenting. A second and corollary First Amendment principle is the listener's interest in receiving information. See Murphy v. Missouri,
Murphy versus
603
Missouri. I have not heard of
U.S.
that.
43, 75, 2024.
Okay, so if I had just
Klein
run the
needs to
cleric
be
earlier, I'd be good. But I'm dumb and didn't do
Mandel,
that. I now know that clerics can
408
trade for
U.S.
pearls. I saw one earlier. No idea where that is now.
762,
Genuinely not even kind of an idea.
1972. In the professional med. Eichel context, however,
Right, we're officially speeding up the
informational
voice.
asymmetry shapes the listener's interest. To be sure, R. Respect for patients. O. Autonomy is a cornerstone of medical ethics. American Med. Eichel Association Code of Medical Ethics, Opinion 11.2.4. Transparency in Healthcare, 2026. But that interest is not served by receiving all existing opinions, only in for Matt Ion about treatments that are within the standard of care advances patients' interests. Ibid, P. Physicians have treatment. The concurrence purports to save, for another day, the case tie-in whether, content-based but viewpoint-neutral laws regulating speech in doctors' and counselors' offices, comport with the First Amendment.
Yes, I have my compass and I can just head
4,
towards
opinion
it.
of Kagan, J.
Let me get back
But
to
that
spawn.
magnanimity is a me rage. Standards-based regulations exist in the medical context precisely because the state has a view about safety or efficacy. Regulation is a state's police power prerogative to promote those views, as the standard of care, while simultaneously rejecting all others. The laws I reference in Part 4, Infra, are not examples of content-based, viewpoint-neutral laws, as the concurrence maintains.
I need to look at the...
Contra, anti, at 4, N, star.
I have to actually look
Rather,
at
when properly
the reading
analyzed,
more
those
often
laws
like
are either
this.
facially viewpoint-based, see, e.g., the requirement that the medical professional must not provide care, in a cruel manner, Kansas Admin, Regs. 102.3.12a, b. 11, 2022, or unavoidably viewpoint-based in applica. Tie-in. Consider, for example, a therapist disciplined for failing to provide care that promotes the best interests of her client. See GA Comp, Rules and Regs, Rule 135, 7.01, 1, 2026.
Right, do these
Punishment
bozos
for
got a
violation
cleric
of
or
that
no?
standard requires the state to impose its view of what a therapist should have said or done, and would necessarily
I don't
reflect
think this
state's
village does.
disapproval
Or
of the speech the
even
therapist
likely will
actually
at all.
employed. See Madel versus Tam.
That's a farmer.
582
It's fisherman. Oh, I think this one might have a cleric.
249, 2017.
But I threw away my nether warts, so
concurring in
I
part
can't make
and
another wart
concurring in
farm.
judgment. But, of course, imposing the state's view of what is appropriate is the entire point of standards-based regulation. The First Amendment allows this because the state is regulating professional conduct and this professional speech is
That
only
is
being
indeed a
incidentally
cleric,
restricted.
actually.
The analysis does not turn on whether the state's regulation is viewpoint neutral. Neutrality is not, and cannot be, the touchstone of the laws that govern the quality of care that professionals provide to
Okay,
patients.
I did just level them up all in one go. That's a huge
Side S,
difference.
607 U.S. _________2026.
We leveled up, buddy?
Jackson, J. Dissenting.
You'll now trade me emeralds for
23.
whatever.
An obligation to inform
You'll trade me
patients about all
gold
appropriate
for
treatment
emeralds, and then I
options,
can trade you
emphasis
your
A.
emeralds back to you.
Patients are not in a passive
Okay,
island to wait
fine.
for
I'll
medical
get rid of this
discourse
gold that
and
I have.
independently evaluate the best treatment for their circumstances. Their interests as
See what
listeners are
they
thus
can
limited
do.
by the nature and purpose of the professional-patient relationship. Third, and finally, the First Amendment protects a speaker's autonomy. The fundamental rule of protection under the First Amendment is that a speaker has the autonomy to choose the content of his own message. Rumsfeld vs. Forum for Academic and Institutional Rights, Inc., 547 U.S. 47, 63-64, 2006, quoting Hurley vs. Irish American Gay, Lesbian, and Bisexual Group of Boston, Incorporated.
Well, there's
515
18 that I can trade with him real quick.
557,
Let's just see what we can do.
1995. But, here again, with respect to professional medical speech, healthcare providers do not have autonomy. When it comes to providing
I just
treatment
pushed him
for
a
their
lot higher.
patients,
That's
they are
exciting,
bound by the
maybe.
standard of care and
Okay, let him
are not
evolve
generally
again.
free to choose the
Let
content
him
of
evolve.
their MES. Sage. C. Hopt, 125 Yale L. J. at 1272, Halberstam, 147 U. Pile, Rev. at 867.
Okay.
Put differently, although medical professionals do have an autonomy interest in communicating their ideas to the patients they are treating, that interest only extends to treatment-related
yeah,
advice
let's go ahead and
informed
keep
that
spamming
is
this until
consistent
we
with the
can.
standard of care. In my
Okay,
view, the
not
majority
great,
is
but
mistaken
whatever.
to equate treatment-related speech rendered in the context of providing medical care with any spoken words uttered by any other speaker. See,
2,
e.g., ante,
3.
at 11.
Oh,
While the
we were
First Amendment
close.
protects many and varied
We were
forms of
close for a
expression,
second.
the spoken word is perhaps the quintessential form of protected speech.
None
that
of
is
these I
exactly
can
the
get
kind of
quickly or
expression in which
efficiently.
Ms. Chiles
Oh,
seeks to engage.
Jesus.
The majority is also wrong to insist that it
Maybe
is
I can get
antithetical to
more
the First
emeralds
Amendment
from
for a state
other
to incidentally
villagers.
restrict a healthcare provider's treat. Ment-related speech based on a
The fisherman wanted
standard
something,
of
didn't he? I just don't know if he'll
24
be
Chiles
efficient.
v. Salazar.
Wait,
Jackson,
what do you
J.
want?
Dissenting.
You'll take 26 potatoes
Care
for a
because
singular
an
one of
Eddie-Cal
those.
consensus
Okay
is
then.
not static. It evolves and always has. Anti.
26 for 1 does not sound worth it to
The
me, bud,
mutability
but
of medical
whatever.
standards tells us little about the First Amendment's scope in a country where medical standards are enforceable by law and govern the treatment-related conduct of professional healthcare providers.
You're not even growing a single
Like it or
potato.
not,
How do I
treatment standards
give you
exist
one
in
then?
America. And those standards necessarily reflect the expert medical community's current beliefs about the safety and efficacy of VAR-ES medical treatments, whatever those beliefs might be. Medical standards are driven by science, objective facts and data, but, naturally, they are not
You ain't got no
viewpoint
potatoes.
Consequently, the people
How am I
win,
going to trade
not
you
lose,
potatoes if you
when
ain't
a
got
state
potatoes to trade?
incorporates the medical profession's viewpoint into laws that require licensed treatment providers to conform to prevailing standards of care. Contra,
Fisherman, what do you
ante,
want?
at 22, suggesting otherwise.
20
For this
strings?
reason, the court has long
I haven't
recognized
kept
a
string on me the entire time.
state's power to regulate to
But if I
protect
give
its
you
residents
cod
even in
and an emerald, you'll give me cooked cod. That
face of
doesn't
uncertainty.
sound... That's not useful.
C.F. Gonzalez vs. Carhart, 550 U.S. 124, 163, 2007, collecting cases and noting the wide discretion afforded state legislatures to
No.
pass legislation in areas where there is medical and scientific uncertainty. Point 9.
Dang it, I was literally just a couple of emeralds
Nine,
off of
majority
getting
limits
the guy to where he needs to be.
consensus is not static. A law like the MCTL
Because if I could
might
just get
operate
him
with
to
silent,
the point of letting me
professional
do
speech go ing forward
glass
even if
bottles, I
medical
could make a bunch
consensus
of glass
wouldn't be
bottles from
other way.
glass.
Anti, at 22. Illustrating this problem, the majority points to shameful parts of this country's past to show the dangers that can come from
Farmer.
regulation that relies on outdated medical
More
practices.
fishermen.
Ibid, citing
Just
Buck
a
vs.
farmer.
Bell, 274 U.S.
God
200,
dang it, I don't know what to
205
do. All y'all can have bread, though. I
1927.
got infinite bread
But
at
the
this point.
majority does not mention that, if the standard of care does change, the
Dang
state
it!
legislature has the power to change the law in response to that evidence. The majority's point seems to be that states should not be permitted to enact, rigid, laws based on current scientific thought because expert
Alright, well then
opinions
I'm
might
just gonna
shift
keep
over time.
moving. That's all I
But
can do,
those
really.
uncertainties, which have always existed, are no reason to abandon medical standards or to alter how the law has traditionally accommodated scientific discoveries. The potential that medical consensus may change in the future does not mean that the Constitution prevents. Cite as 607 U.S. ______, 2026. Jackson, J. Dissenting. 25. Put differently, states impose treatment standards incorporating the current consensus of medical experts to protect state residents from harm. And they do this to ensure that professionals provide patients
No,
with
there's definitely
high-quality
not
care.
going to be any Enderman.
A state that, alternatively, pursues an agenda of purposefully silencing critics, muzzling opponents, or targeting views it considers threatening would, of course, violate the First Amendment. But it behooves us all, and especially courts, to see and know the difference. Ultimately, then, no traditional First Amendment principle justifies preventing a state from regulating medical care simply and solely because its law happens to restrict treatment-related speech. And in this case, there is zero evidence that Colorado has engaged in the corrosive and illicit suppression of ideas that the First Amendment valiantly opposes.
Lightning strikes.
The record here does not show that Chiles is being target, ed, or muzzle, d, or silenced, or itsen. Sor, ed, as the majority suggests. Anti, at 14, 15, 22, 23.
There really was a time when I was a free speech absolutist, and I was like, I'm always going to stand by this concept, but at some point I realized that the Supreme Court is extremely corrupt. They're extremely old. They need term limits.
A state from acting today to
The Supreme Court needs to be completely reworked altogether in the United States.
Harmful medical treatment. 10 Under my analysis, evidence of speech targeting or suppression could include the fact that the challenged state regulation does not, in fact, reflect.
And now I'm not really a free speech absolutist.
See anti, at 22, noting the mutability of the
The spirit of free speech, absolutely, but the letter of law for free speech, I don't care as much about as I used to, because like, these guys are all elitists and out of touch and not reflecting reality. Obviously, there should be a way that our legal system operates such that conversion therapy can be just completely banned because we're allegedly a civilized society. That should be possible, and it should also be possible that for some reason a kid tells their doctor, tells their counselor, hey, I want to wrangle my attraction to same-sex people. I want to reduce it. I want to be more hetero. Then yeah, if the kid totally autonomously does that, let him. But also ban proper evil conversion therapy. Do both. That shouldn't be impossible.
Jackson, J. Dissenting. Only incidentally restricts professional medical speech as a result of Colorado's regulation of a harmful medical treatment. Nothing compels the conclusion that a state
I know where I am now.
restrict this kind of communication in this way is targeting speech qua
I am near spawn indeed.
3. The centuries-long tradition of states using their police powers to establish and enforce the standards of care that bind medical professionals, including those who use speech to administer treatments, is another indication that heightened scrutiny does not and need not apply here. The majority's opinion largely omits this broader historical record.
Jesus.
But, when consulted, that history demonstrates unequivocally that the MCTL is neither unusual nor inherently suspect. States have always had broad power to establish standards for licensing practitioners and regulating the practice of professions. Goldfarb vs. Virginia State Bar, 421 U.S. 773, 792, 1975. With respect to the medical profession in particular, states have used that power to control how
I'm pretty
medicine is
much at
practiced
spawn.
from time immemorial. Dent vs. West Virginia,
I
129
thought so.
S. 114, 122, 1889.
Just where the hell am I?
States have historically regulated the medical profession in two complementary ways, licensing schemes and medi. Cal malpractice
Well,
liability.
maybe I can find an
Both
island
necessarily
with
encompass
that's
three.
super flat.
Restrictions on professional medical speech through the regulation of the provision of medical care. Medical licensing began as early as 1639, before this country was founded. Art Horowitz, in the public interest,
Okay, yeah, there's
Medical Licensing and the Disciplinary
thingy
Process
that I made.
39, 2013. Many states deregulated in the mid-1800s by abolishing their licensing schemes. ID, at 40. But regulation through licensing was not abandoned for long. By the turn of the First Amendment yields to reasonable conditions that states impose on medical providers. Cite as 607 U.S. ______, 2026. Jackson, J. Dissenting. 27. 20th century.
I just
12
heard
states
a
had adopted
freaking
licensing laws.
Triton.
D. Johnson and
Be
H.
thrown at me.
Chaudhry, Medical Licensing and Discipline in America, A History of the Federation of State Medical Boards 23, 2012. We held that such laws were a permissibly exercise of a state's traditional police powers, declaring that, the power of the state to provide for the general welfare of its people authorizes it to prescribe all such regulations as, in its judgment, will secure or tend to secure them against the consequences of ignorance and incapacity as well as of deception and fraud. Dent, 129 U.S. at 122, see also Watson vs. Maryland, 218 U.S., 173, 176, 1910, reject ING challenge to medical licensing
I think
law.
I might just call it.
Today,
Like, I'm
every
kind
state
of
has a
tired.
medical licensing scheme.
And I'm not gonna
See
win.
app to brief for health law scholars as amici curiae. In practice, medical licensing serves two functions, both
God dang
essential
it.
to patient safety. First, as the majority emphasizes, Lee.
Oh, and I'm just sore.
Sensing sets limits on who may practice medicine. CP. Larkin, M.
All right,
Fishbaugh.
I'm
L.
speeding it up
McCarthy.
even more.
Telemedicine and OC Occupational Licensing, 73 Admin, L. Rev 747, 774, 2021, Ante, at 20.
I think
But
we're
the second
chilling
function
and
is
just
more
kind of
important in
calling
this
it,
case. State licensing
honestly.
laws also regulate how those professionals may practice, by requiring them to adhere to a standard of care. See brief for respondents 27. See also app to ID at 188A listing state laws that require medical and mental health professionals to be licensed and to comply with professional standards. While licensing regulates medical professionals ex ante, medical malpractice lawsuits enforce those standards ex post. And just like medical licensing, the tort of medical malpractice has a long pedigree. English common law held doctors liable for harm caused by their negligent medical treatment. 3W. Blackstone, Commentaries on the Laws of England *122, W. Lewis edition. 1922, 1768. The English tradition carried forward, this legal claim has been available in our country since the founding. C.K. DeVille, Medical Malpractice in 28 Chiles v. Salazar. Jackson, J. Dissenting. 19th Century America, Origins and Legacy 3, 5, 1990, DeVille. In the mid-1800s, the number of malpractice cases skyrocketed, filling the void left by the state's temporary deregulation of medical licensing. See ID, at 2534, see also ID, at 115 to 137, Graham vs. Gautier, 21 Texas 111, 117 to 118, 1858, observing that the lack of a licensing scheme demanded enforcement of a corresponding standard of care. Historically, the medical malpractice tort generally required the plaintiff to prove three things: 1, that there was a professional-patient relationship, 2, that the medical professional had caused him harm, and 3, that the pro-vider had departed from a standard of care. DeVille 4650. The majority focuses on the requirement to show harm. Ante, at 21. But the entire point of the third element was to reinforce the standards that govern medical practitioners. For that reason, the harmed plaintiff was required to establish that the accused physician had not practiced with ordinary care, diligence, and skill. See DeVille 49, M. Faces deleted. State enforcement of the standard of care, i.e., the care, skill, and knowledge regarded as competent among similar medical providers in the same or similar circumstances. Restatement, 3rd, of torts, medical malpractice section 5,
I'm
10.
tired.
Draft number 2, March 2024, has continued over time and still serves as the touchstone for both licensing schemes and medical malpractice lawsuits. Brief for respondents 25, 26, and app to ID at 188A. That is, states have consistently regulated medical professionals' conduct to ensure that modern healthcare practices conform to the standard of care through both medical malpractice law and professional licensing. Note, too, that such state regulation has not been limited to medical procedures. Physicians have historically been held liable for what they said when administering those procedures as well. See Graham, 21 Texas, at 119 to 120. Cite as 607 U.S. ______, 2026. Jackson, J. Dissenting. 29. Imposing liability for medical advice, Edwards v. Lamb, 69 N. H. 599, 45 A. 480, 1899, Skillings v. Allen, 143 Minnesota. 323, 173 N. W. 663, 1919. Moreover, in the past, states have, as part of their licensing regulations, defined the practice of medicine to cover practitioner speech. See E.G. Smith v. People, 51 Colorado 270,
All right, back to it, I guess.
117 p. 612, 613, 1911, noting that the practice of medicine, as regulated by Colorado's licensing law, included suggestion, S or recommendation, S, of treatment. In short, states have regulated professional conduct related to the provision of all kinds of medical care, and incidentally restricted speech, without constitutional affront for eons. Though the majority averts its gaze, even occurs.
Oh man, I can give that cleric a million of these finally.
States have traditionally played a significant role in setting the standards that govern the medical profession. See Washington versus Glucksberg, 521 U.S. 702. 731, 1997, emphasizing the state interest in protecting the integrity and ethics of the medical profession. Barsky v. Board of Regents of University of N.Y. 347 U.S. 442, 451, 1954, saying, with the MCTL, Colorado has merely taken up that same mantle. That law operates by prohibiting a particular medical treatment the state considers harmful, and nothing about it implicates Chiles's First Amendment rights in a markedly different fashion than other states' traditional EF forts to regulate and enforce the standard of care. Point 11. 11. The majority's observation that Counselor Licensure Bill S are a relatively recent innovation, ante, at 20, is an interesting diversion.
Or I would
That
need
is all.
20. I just don't know
Relevant
about
historical
that.
question is
That's
whether
kind of
states have
ridiculous to
historically
think
regulated
about.
medical care that licensed professionals provide to patients, including treatments that are delivered via speech. The answer is yes. The fact that counselors have only recently been included in the regulated category of licensed medical professionals is beside the point. 30 Chiles v. Salazar. Jackson, J. Dissenting. One more thought on this. The majority rigidly imposes a history and tradition test that treats the plethora of historical examples as insufficient. See ante, at 18 to 22. But it should instead find the long tradition of state laws setting standards of care by regulating the professional conduct of medical providers, including those who treat with speech, doubly reassuring. For one thing, this history helps us to be confident that what Colorado is doing here is actually regulating medical care, not suppressing messages. The record shows that states have routinely enacted laws that establish and enforce the standard of care, and that serves as a backdrop for an understanding of how states have acted historically to protect their residents from harm. The majority is right about one thing, however: a state will always say that its law just regulates the provision of medical treatments, while the challenger will inevitably argue that the state's law nefariously targets speech qua speech. See ante, at 16. A lengthy tradition of similar regulatory efforts by states, or the absence of one, helps courts to ferret out who has the better of that argument. The history also helpfully demonstrates that a lower level of scrutiny is appropriate here, despite the impact of the MCTL on Chiles's speech. We can rest easy, comforted by the fact that this law is not actually operating to suppress the expression of thoughts, messages, or ideas about conversion therapy. Instead, the MCTL restricts talk therapists in the same way and to the same extent as other healthcare professionals have historically been limited when treating patients. Like other valid licensing restrictions, the MCTL does not prevent Chiles from speaking out in favor of conversion therapy.
The dissent is being pretty rational.
Efforts to validate that therapy. All this law does is prohibit Chiles from providing this treatment to minor patients, no different than what Colorado and other states have been doing in the cite as 607 U.S.____2026. Jackson, J. Dissenting. 31. Indisputably valid exercise of their police powers for Sentu. Rise. Point 12.
I've already been here.
All things considered, then, I reach a different
Wait,
conclusion.
no, there's a golden apple. I don't recall a golden apple. And a lodestone? Frickin' lodestone? Seriously?
Scrutiny is warranted.
I haven't been here, I
The First
think.
Amendment cares about government efforts to suppress speech as speech based on its expressive content, not laws that, like the MCTL, restrict speech incidentally due to the government. Men's traditional, garden variety regulation of such speak. Heirs professional conduct. 12 suggesting otherwise, the majority places great stock in our decision in Holder versus Humanitarian Law Project, 561 U.S. 1, 2010. See ante, at 10:16. Holder involved a law that prevented lawyers and doctors from providing material support for others' terrorist activities by word or deed. 561 U.S. at 8-9. We subjected the law
By
to strict
word
scrutiny
or
because,
deed.
as applied to the plaintiffs, the law was aimed at preventing profession ALS from communicating a message. ID, at 28. Such a regulation plainly raised the specter of suppression, i.e., that what the United States was really aiming to do was prevent those professionals from expressing support for something the United States found distasteful. In other words, the challenged law sought to punish the plaintiffs based on the expressive content of their speech. That is not what we have here. The MCTL, which follows in a long line of state regulation of healthcare providers' treatment-related conduct, does not restrict or punish Cal professionals because of the expressive content of their communica tie-ins. Rather, the speech restriction happens only incidentally. The MCTL's indisputable objective is prohibiting a harmful medical treatment. To put a finer point on this, the equivalent of Chiles's First Amendment claim, transported to the Holder context, would be as if the United States in Holder had said, "You professionals are prohibited from committing acts of
Leave me
terrorism,"
alone,
and the
witch.
lawyers among them responded, "It is unconstitutional to apply your no terrorist acts prohibition to us because we want to commit the prohibited terrorist acts with our speech." But, of course, the First Amendment would not prevent the United States from prohibiting all terrorist acts even if, by doing so, it incidentally restricts the speech that some actors might otherwise have used to behave in the manner the law prohibits. In my view, that is how Chiles's constitutional claim works, and also why it fails. 32 Chiles v. Salazar. Jackson, J. Dissenting. For ultimately, because the majority plays with fire in this case, I fear that the people of this country will get burned. Before now, licensed medical professionals had to adhere to standards when treating patients. They could neither do nor say whatever they want.
But after
Largely
this,
due to such
it
state
could make it
regulations,
so
Americans have been privileged to
medical
enjoy a long and
professionals
successful
don't have to
high-quality
adhere
medical
to
care.
standards as much as
Today,
before?
the court turns its back on that tradition. And, to be completely frank, no one knows what will happen now. This decision might make speech-only therapies and other medical treatments involving practitioner speech effectively unregulatable, not to be reached via licensing standards, medical malpractice liability, or any other means
I
of
have
state
so
control.
much stuff.
Who knows? Certainly not the majority. It appears to have made this momentous decision without
And yet,
adequately grappling with the potential long-term
I am
and disastrous
probably not going
implications
to
of
win
this
soon.
The fallout could be catastrophic. Many regulations impact the speech of medical professionals in the context of their provision of healthcare to patients. The possibilities go far
It's a
beyond
weird
talk therapy
fish.
and informed consent. For exam PLE, many states require that medical professionals make every reasonable effort to promote the welfare, autonomy, and best interests of the client. GACOMP Rules and Regs, Rule 135, 7.01, 1, 2026, CIND Admin, Code, TIT. 839, Section 1, Section 551, 2026,
Thanks.
on General Stat Section 17.8,
Okay, not
542,
good.
requiring H. Humane and Dignified Treatment, 2025, a la Admin. Code Rule 255, X 11.01, Sup. 2016, requiring that the
Is
professional
that
ensure client welfare
witch
and protection
currently
during medical care.
trying to get to
Some
me?
states further prohibit medical probe
Still?
science from treating a patient in a cruel manner. Kansas. Admin Regs.
What?
102, 12A, B,
What a
11,
dedicated
2022.
witch.
Similarly, some cite as 607 U.S.____2026, 2026. Jackson, J. Dissenting. 33. Licensing boards can discipline.
Yeah, I
providers
definitely
using
accidentally
content.
put myself in a
Alaska
direction I've
Stat
literally
Section
never been,
08.29.404,
so that's not great, but whatever.
2025.13 on the majority's view. These kinds of regulations become unenforceable if the healthcare
Oh,
provider
I'm
risks
so
harm
cooked.
possible
I've
to
just
their
ended
speech
up in a
rather than
random
moderation.
direction.
Private heirs who offer cruel, speech-only therapies or who use speech to, intentionally or incompetently, harm the welfare of patients, for example, can now assert a First Amendment right to carry on, regardless of these standards. So, to put it bluntly, the court could be ushering in an era of unprofessional and unsafe medical care administered by effectively unsupervised healthcare providers. A state license used to mean
Just to mean
means
something
something
to
to patients who entrust their care to licensed professionals, i.e., that the person is certified to be one who provides treatments that are consistent with the standard of care. That stops today. Indeed, it is not at all clear how, or to what extent, state regulation of medical care involving practitioner speech can survive this holding. We are on a slippery slope now. For the first time, the Supreme Court has interpreted the First Amendment to bless a risk of therapeutic harm to children by limiting the state's ability to regulate medical providers and treat patients with speech.
Wow.
What's next? In the worst-case scenario, our medical system unravels as various licensed healthcare professionals, talk therapists, psychiatrists, and presumably
Presumably anyone else who
utilize speech when
claims.
administering.
Yep.
13. Those are not the only restrictions that constrain the speech of med medical
Whoa,
professionals.
this person's
Some states
thinking
require that a counselor make a
ahead.
treatment plan specifying goals and methods, and ensure that such plan is viable and effective. Arizona
These are
Admin Code, Rule
legitimate
R4, 6,
concerns
1102,
for the
is
side effects of this
20.5.
ruling.
Others prohibit making claims of professional superiority that one cannot substantiate or guaranteeing that satisfaction or a cure will result from the performance of professional services. Kansas Admin Regs 102.3.12a, b, 31, 32. Still others prohibit the professional from exercise undue influence on the client. Colorado Reverend Stat Section 12, 245, 224, J. 34 Chiles v. Salazar. Jackson, J. Dissenting. Treatments to patients start broadly wielding their newfound constitutional right to provide substandard medical care. It is baffling that we could now be standing on the edge of a precipitous drop in the quality of healthcare services in America. But the court sees fit to bring us one step closer to that fate today. Stranger still is the fact that this possibility looms in the 21st century, given what science now enables us to know about medical conditions and treatments, what our cases say, and what we all should have learned by now from history. Somehow, justices from eras past have always understood that, as I stated at the outset, there is no right to practice medicine which is not subordinate to the police power of the states. Lambert, 272 U.S., at 596. They correctly applied that simple but powerful understanding of our Constitution across the board, to all healthcare professionals, including those with practices. That happened to involve treatment-related speech. We do harm to both the nation's medical system and our First Amendment jurisprudence by ignoring that wisdom today. Asterisk, asterisk, asterisk. The First Amendment requires heightened scrutiny when states regulate speech as speech, but not when speech is restricted incidentally. NIFLA, 585 U.S., at 769 to 770. The latter occurs where, as here, a state seeks to prohibit healthcare professionals from providing a dangerous medical treatment in all of its forms, including the speech-related variety. States have traditionally regulated the provision of medical care through licensing schemes and malpractice regimes without constitutional incident. And no core principle of our First Amendment jurisprudence leads inexorably to the conclusion that it violates the Constitution for a state to prevent its licensed talk therapists from using speech to harm the minors in their care. Hold ing otherwise, as the majority does now, flout centuries of. Cite as 607 U.S. ____ 2026. Jackson, J. Dissenting. 35. State standardized regulation of medical care and is, ultimately, nonsensical. The Constitution does not pose a barrier to reasonable regulation of harmful medical treatments just because substandard care comes via speech instead of scalpel. Accordingly, I cannot agree with the majority's analysis or its conclusions in this case. The majority finds, at bottom, that Colorado likely cannot legislate to protect the children of its state if, by doing so, it happens to keep state-licensed healthcare providers from saying what they want to say to minors. And the majority's holding means, in effect, that just because Chiles is a talk therapist, and not, say, a surgeon, a state can be prevented from incidentally imposing reasonable restrictions on the treatments she provides. Our precedents do not compel this conclusion. In fact, NIFLA draws a different line, and the correct course of action here is to hold it, speech uttered for purposes of providing medical treatment may be restricted incidentally. When the state reasonably regulates the speaker's provision of medical treatments to patients. ID, at 769 to 770. To do anything else opens a dangerous can of worms. It threatens to impair states' ability to regulate the provision of medical care in any respect. It extends the Constitution into uncharted territory.
Sometimes these SCOTUSes
and it ultimately risks grave harm to Americans'
have
health and
like
well-being.
prophetic understandings of how the future may turn out. It was interesting that this particular justice spent the major part of their dissent just trying to stick to the constitutional precedent and speak very formally as a judge. But at the very end, they're just like, yeah, by the way, the logical outcome of this is that psychiatrists and other professionals with licenses are now going to use this as justification to do toxic, dangerous, or just inefficacious things because it's their free speech right to. Great. There probably will be a follow-up on this case. I can see it coming and what form it takes when someone challenges this later in a different format. Well, what are my final thoughts? Colorado should have written this in a way that was harder for the Constitution to shoot down, because now the Constitution has taken a ruling on it and opened up a different can of worms as a side effect. Conversion therapy should be banned on the basis that it is abuse and torture. Simultaneously, counselors should have a right to casually talk to their patients about pretty much anything. But obviously, treating in a material way, you know, you shouldn't be allowed to do conversion therapy. Simple. Just like you shouldn't be able to, just like a counselor shouldn't have the right to, you know, gaslight a schizoaffective patient into believing that the voices they're hearing are real. You shouldn't be able to do materially harmful things to your patients. Simultaneously, you should be able to have casual conversations about whatever works. But I feel like I see the gray. I see the complicatedness of this here. If I were to fall into one of the sides with the justices, where would I have probably fallen? I probably would have fallen with the majority here and said, yes, we shouldn't regulate what a counselor can say to and with their patients. But I guess maybe I would be on the side of the dissent here ultimately, because I would understand with my brain that talk therapy in psychiatry and psychology is as much a procedure as is, like, you know, doing a procedure surgically, right? It's as much medical care as it is a heart transplant. It's as much medical care as it is an ultrasound. And if you employ medical care knowingly that is deleterious and toxic, you should be able to be held accountable for that. So I think it's pretty straightforward. You ban conversion therapy, but you don't ban discussions of a patient's feelings towards their sexuality and gender. That's like the simple, obvious conclusion. How would you rule then? I guess I would still ultimately rule the dissent here and say, yes, ban conversion therapy first and make a free speech exception later. That seems more common sense to me, but that's just my opinion. All right, well, thank you so much for watching. I've officially lost because the document is over. I'm okay with that. I will say we made pretty good progress. I almost beat it this time. I think maybe I just need to learn more about ways to get ender pearls efficiently. So that way while doing runs, I can not be held up by that aspect of the run. All right, take care. Goodbye.